Tractate Bava Kamma discusses the laws of damages, be they to a person or to property, and their repayment, along with the laws and prohibitions of theft and points on monetary repayment. Chapter 1 will begin a discussion on the different types of damages and their laws. The first Mishnah says, there are 4 primary types of damagers: the ox, the pit, the maveh, which will be defined later, and fire. The ox is unlike the maveh, and the maveh is unlike the ox. Both these, which are living things, are unlike fire, which is not a living thing. These 3, the ox, maveh, and fire, travel to damage, unlike the pit, which remains in its place. The common denominator is that these are all things which damage, and their owner is obligated to watch them. If they do damage something, the owner of these is obligated to pay for it from his best quality land. The Gemara says the fact that the premise was listing primary categories, the implication is that there are also subcategories, similar to the categories and subcategories of the laws of Shabbos, wherein you'd have 2 liabilities for violating 2 different main categories, or 2 subcategories of 2 separate categories, while if you violated a main category and one of its own subcategories, you'd only be liable for 1 violation. Others say there is no such practical difference by those laws of Shabbos, and the main difference is just one of terminology, as main categories are works performed within the tabernacle, and everything else would be a subcategory. It also mentions by the laws of impurity, which also has this concept of categories and subcategories. So, in regards to categories and subcategories by the laws of damages, it says some subcategories have the same laws of main categories, and others do not. For instance, the ox itself has 3 main categories of damaging: its horn, referencing goring, its tooth, referencing eating, and its foot, referencing trampling, which is based off of scriptural verses. The subcategories of the horn and the concept of goring have pushing, biting, squatting, and kicking, forms of intentional, deliberate damage. It debates as to what exactly pushing refers to, if it references pushing with horns, goring essentially, or pushing with the body. Based on verses, it said goring implies a deliberate attack, like on a person, while pushing is a more spontaneous action, like on an animal. This additionally teaches that an animal which becomes presumed to attack people is also presumed to attack animals, but not vice versa. In regards to the subcategory of biting, this is a subcategory of horns and not teeth, as teeth refers to when the ox gets physical gratification from the damage. Squatting and kicking are categories of this and not foot, as foot refers specifically to more common occurrences. The subcategories that are similar in law to the main category here would be the subcategories of the horn, and the ones that would be different would possibly be the subcategories of teeth and foot. It cites and discusses the scriptural sources for these categories of tooth and foot. The subcategories of tooth are the animal rubbing itself against a wall to scratch, or using the restroom on top of produce. Based on the fact that the main category and its subcategories both involve the animal being gratified from the damage, the responsibility to watch the animal should be on the owner by both. So apparently the laws of the tooth main category are the same as its subcategory, similar to the horn category and its subcategories. The subcategories of foot would be the animal damaging with its body as it walked, with its hair as it walked, with its pack, with its bit, or with its bell. However, again, the categories and subcategories are similar. It's damage that's common, and the owner is responsible to watch them. So, rather, when it was stated that there are some subcategories that are different than their categories, that apparently couldn't have been referring to the ox at all. It must have been referring to the pit. The subcategories of a pit are debated. It suggests the main category is a pit 10 handbreadths deep, which causes death, and the subcategory is one of 9 handbreadths deep, which is enough to only cause injury, but that would just be 2 different main categories of death and of injury. So rather, the subcategory of a pit refers to a stone, knife, or otherwise left in a public domain that could cause damage to somebody. If declared ownerless, it would be agreed that the item would be a subcategory of a pit. If it's not ownerless, it's debated if this is a subcategory of a pit or of an ox. However, this subcategory again has the same laws as the general category, in that it's something that can damage from its inception and must be watched from that point. So again, this subcategory is the same as its own category, so the difference must refer to something else. So we bring the third source of damage, a maveh. The definition of a maveh will be defined more later. Some say it refers to Shane, which will be discussed, and some say to a man. If a man's subcategory is damaged when he's asleep, that has the same laws as learned elsewhere. So his different subcategory could possibly be saliva or mucus, but that's just considered to be an extension of the man's force if it damages while moving, and if it's standing still, it's agreed to just be a subcategory of a pit. So again, the subcategories of a maveh are the same as their main categories. So the difference between categories and subcategories could possibly be within fire. However, the subcategories of fire, an item being blown off of a roof, is something which damages with another force mixed in, the wind here. And is obligated to be watched, which is the same as its main category. So it says to find the difference in law between a subcategory and main category, we have to go back to the subcategory of foot within an ox. Specifically, a subcategory of damage when pebbles shoot out from the ox's foot as it walks, where half damage is paid, being a tradition from Mount Sinai. Now, this would be the subcategory, as it's also paid from best quality property, or possibly as it's exempt from damage within a public domain, so it's unique. So, that's that. As mentioned, there's a debate as to what exactly mother means. Some said it was a person, some said shane, an animal's teeth, essentially, which is based off of verses. The opinion that says it's the ox's teeth, he holds the category of an ox is specifically referring to its horn, while mother, shane, refers to the animal's tooth, with the difference being if the animal is gratified or not by its action. It possibly could create a difference between damage done by a person or through a slave, but others reject this difference. He additionally explains the verses referencing the subcategories of horn and foot, and as to why he debates the interpretation of mother meaning a person. The categories all reference things that tend to damage things, so if it does in fact refer to a human, it would have to be a sleeping human who damaged things as he moves in his sleep. If further debates based on the wording what mother exactly refers to, some suggest a third explanation, which is that it means water, but that's disproven based on the wording of the verse. Some suggest it means fire, but that can't be it, as fire was already used as the last one. There's a source which gives an expanded list of primary categories of damagers: an unpaid custodian, a borrower, a paid custodian, a renter, damages, pain, healing, unemployment, and humiliation, plus the 4 from our Mishnah. Now, by our Mishnah, it excluded the first number of those. If it was like the opinion that mother means an ox teeth, this makes sense, as he'd only be discussing damage by property, not by a person. So according to the opinion that a mother means a person, it must be that there's variation in discussion between direct and indirect damage based on that source. There's actually a longer list of primary forms of damage, including for double compensation, times 4 and times 5 compensation, a thief, a robber, discredited witnesses, a violator and seducer, a defamer, a contaminator of impurity, a contaminator with teruma, using wine for an idolatrous libation, and the 13 of the prior list. These additions include penalties, not just compensations, in the prior list. It argues as to why each of these damagers fit into the respective categories, along with the scriptural sources for every one of them. The specification in the Mishnah that the ox is unlike the mother teaches that one damager can't be learned from the other. The specification that the ox and the mother, which are living, are unlike fire, shows that one damager can't be learned from 2 of them, although some say that the pit plus any other of them can alone be used to teach all of the other main categories, possibly besides for the horn, and they were each specified to write their unique laws. The category of horn was specified to differentiate between a regular ox and an ox established to be dangerous. Foot were specified to teach that they're exempt within a public domain. Pit was specified to exempt utensils damaged within it, although others say it's to exempt for a person killed within it. The category of a man was to additionally obligate payment for pain, healing, unemployment, and humiliation, and fire was specified to exempt liability for hidden items it destroyed. Others say it's to exempt damage to non-flammables like a plowed field or stones. When the Mishnah specified that there's a common characteristic, this would include the case of an object, a stone or a knife, that was left on a roof and blown off by a normal wind that damaged somebody, as this creates liability. This is qualified. A second of such cases, something under the category of a pit, a dangerous object that was accidentally kicked around by people until it reached a place of danger that causes liability. Third, damaging things via dumping waste out of pipes during the permitted rainy system. Again, these are more particularly qualified. A fourth derived case of liability, if a privately owned wall or tree was noted to be in danger of falling into a public domain and damaging something, and the owner was given a time frame to have it removed, and after that deadline finished, it still wasn't removed, and it fell, damaging something. Specifically, it was designated as ownerless, but it can't simply be derived as a subcategory of the pit, as that includes things dangerous from their inception, and it can't be part of the category of the ox, which moves around and damages things. So, like the others, liability here is only learned from the combination of these principles. It also says in the Mishnah it used a clipped version of the word for obligated, as he was from Jerusalem and they spoke that way there. It gives argument as to the definition of the best quality of somebody's land in regards to repayment for such damages, as to who in comparison is the quality of the land considered. It's debated. Now, our source says he must pay with his best quality produce, but other sources seem to imply otherwise. It discusses this apparent contradiction further. It argues this topic from a number of additional sources. It's additionally debated as to if the quality of land is assessed from within his own property or in comparison to the world's property. It debates in the interpretation of various seemingly contradiction sources on this. These opinions debate further, and there's additional discussion on this topic. It said for a mitzvah, a person should spend a third, meaning to beautify the mitzvah, a third more than what was typically spent on the mitzvah. It's unsure if this is calculated from the principle or the addition, and it says that anything extra spent will be reimbursed by God. New Mishnah. If somebody is obligated to guard something from doing damage, it's as if he personally caused any damage it causes, and he would be liable. If something was only partially damaged, he's still fully responsible. You are responsible to pay for damaging property that's not subject to the laws of Me'ilah, property owned by a Jewish person, and privately owned property. This would apply so long as the damaged item wasn't in a premise owned solely by the damager, or owned by the damager and damagee. With repayment, he does so from his best quality land. The Gemara quotes a source which says, in regards to being responsible for these things, if the damaging entity is handed into the care of somebody mentally incompetent, like a deaf, mute, insane person, or minor, he's still liable, unless it was fire. This applies if the pit or ox handed over were covered or restrained, and the fire in question was just a coal. The difference is that the ox and pit are likely to become unchained or uncovered, but a coal is not likely to cause a fire. Some say he actually wouldn't be liable for the fire if he gives a coal to somebody mentally incompetent, and that's because the mentally incompetent individual actually takes it and damages with it, unlike the pit or ox, which would damage on their own. An ox damaging generally is stricter than a pit, as there's some additional payments and the ox can't be benefited from, and also the ox proactively damages things, unlike a pit. A pit damaging generally is stricter than an ox, as it can damage from its inception and is deemed to be dangerous and presumed to cause harm initially, unlike by an ox. An ox can be stricter than a fire, again as there's some additional payments and the ox cannot be benefited from, and also the owner is liable if it's left in the care of a mentally incompetent person, unlike by fire. Fire is more stringent than an ox, as it would be deemed to be presumed to cause harm initially, unlike an ox. A pit is stricter than a fire, as it damages from its inception, and also the owner is liable if it's left in the care of a mentally incompetent person, unlike by a fire. Fire is stricter than a pit, as a fire goes out and proactively damages, and it is presumed to be dangerous to consume anything at all, unlike a pit. This list is qualified as to why details were included or excluded from this list. The principle from the Mishnah that you're liable if you caused a portion of the damage is explained, meaning if somebody dug a 9 handbreadth deep pit and somebody else completes it to the danger minimum of 10 handbreadths, the last person is liable. Others debate this principle. Some suggest it could refer to where there's a fire and somebody else decides to add sticks to it. Others disagree, saying either this would definitively cause an item to be burnt through his action or not, so there would be no partial active damage. Alternatively, it suggested it's a partial damage to people. For instance, if 5 people sit on a bench and then a 6th person sits down and it breaks, the last one would be liable. However, again, this isn't really a partial damage, as either it would have broken with him or without him. So the partial damage case is argued further and established to be by the additional man by the bench, but specifically where he leaned on the other men, and his force is considered to be like his own person. There's other suggestions brought. Additionally, in regards to repayment, it said he gives payment for damages. This was learned to mean he repays damage of an animal, for instance, with money, but the other man is responsible to deal with the carcass of his dead animal. It gives a number of scriptural sources for this, along with their necessity. Others debate this principle. Some say the damager must also take care of the carcass if it was a thief or a robber or a borrower. It takes cases that try to prove this, and it's held that a robber and borrower aren't responsible to pay the difference of the evaluated worth of the animal now that it's dead, but that would be a necessary addition by a borrower if the animal did die. It cites unrelated laws by miscarriage and the laws of impurity. There are a number of other additional unrelated laws quoted. These principles are discussed along with sources. In regards to the point that there's only liability if the damaged object is not subject to the laws of Me'ilah, the prohibition to benefit from consecrated property, it argues on the sources for this principle. These are discussed further along with particularities on certain temple offering animals damaging each other, if the repayment can be made from the meat of the animal. There are additional points on this. Additionally, it said that there's an obligation to repay damages specifically for damaging a Jewish person's property, although naturally you would still need to repay whoever's property you damaged, if at least only legally. A person would also only be responsible if it was with privately owned property. For instance, if 2 people were unsure whose ox was the damager, they're exempt. Some say it just means to exclude ownerless property, referring to where somebody else took ownership of your ox. Or it could refer to where the ox gored and then the owner made it consecrated, or ownerless. Sources are cited. Also, the damager is not liable if it occurs on his property, as you could just say, what was your animal doing on my property? If it was jointly owned property between them, he's liable to pay only for tooth or foot category damages. Others disagree and say he's exempt there also. And then afterwards, when it discusses payment, it refers to damages from the horn category. It debates this further. It additionally argues on the status of jointly owned property, if the repayment is for foot or tooth damages, or if he's exempt. It cites and disputes particular cases. It's argued but concedes that damage done on the damaged person's property is paid in full. Damage done on the damager's property makes him exempt. And if done on jointly owned property between them, he's liable for horn category damages and exempt for tooth and leg type damages. New Mishnah. Payment for damages is done by monetary assessment with something worth money before a court on the basis of Jewish free witnesses. The law of these damages include women, and the damaged and damager are both involved in the payment. The Gemara says the monetary assessment is based on the amount of money lost and only involves things worth money, not money itself. Additionally, the assessment must be before a court, meaning an official ordained court only. The requirement for witnesses implies that there wouldn't be liability if the man testified to his guilt prior to the witnesses coming. Others still dispute this point. It cites sources from scripture, but these laws apply to women also. In regards to the payment for horn category damages, which is half, some say it's a compensation, as oxen aren't legally considered to be in a guarded state, and they're not presumed to be dangerous, so he only would pay half. Others say it's a penalty, as they disagree, saying it's in a guarded state, so you shouldn't have to pay at all, but he pays half, so he'll be careful. It brings sources to try to prove if they're considered to be a compensation or a penalty payment. It's debated, and it rules it's considered to be a penalty, which would mean that if an animal killed and ate another larger animal, like a dog to a sheep, this would be considered to be unusual, and there would not be a payment specifically in Babylonia. However, the damaged party can just take property as for payment, and he's not made to return it. Or he could take the court case to a court in Israel, and the damager can be forced to go under penalty of excommunication of a sort. Either way, the damaged party has this excommunication until he gets rid of the damaging animal. New Mishnah. A domestic animal is considered to be not established as dangerous if it gores, pushes, bites, squats, and kicks. Now, all of these create a half payment. There are some instances where payment would be in full. The tooth category of an animal is established to be dangerous towards things it would typically eat, as would its foot towards things it would typically break while walking. There's also an ox that's generally established to be dangerous after it damages something through the horn category 3 times. There's an ox that damages on the damaged person's own property, where the damager would pay in full, and a man that damages. A wolf, lion, bear, leopard, snake, and others are established as dangerous, so payment would be in full. Others say these, besides for a snake, could potentially not fall into this category if they're domesticated. The Gemara mentions this Mishnah must be like 2 separate opinions based on differentiation on the penalty for property damages. Others dispute this and adjust the wording, which is qualified. Additionally, it says that there would not be a presumption of danger by squatting if it's by large jugs, but it would apply by small ones, which are more commonly damaged in such a situation. It defines some of the mentioned animals. Some say one of them was a type of demon, and there are related points. It said if somebody's lion attacks in a public domain, he's exempt if it pounced on an animal and ate it, as that's typical behavior, similar to an animal eating fruits. If it attacked and tore apart an animal, he'd be liable. This would apply if it tore apart an animal for itself, not if it did it for its cubs or a lioness or to store in its lair. Others say lions do actually typically tear apart animals, so the liability would be specifically for a domesticated animal. According to them, full payment would be required, as this lion was presumed to be dangerous, as it had attacked 3 times before. However, it's still not a perfect fit, as this case was taught as a subcategory of tooth, while according to this, it should be a subcategory of horn. New Mishnah. An animal can either be presumed to be safe, called tum, or presumed to be dangerous, called muad. The difference is a tum, an animal presumed to be safe. If it damages, the owner pays half. If it was muad, presumed to be dangerous, the owner would pay in full of aliyah. The Gemara says paying in full of aliyah just means paying with the best property, and it cites verses to show this translation. It says and discusses a number of related verses. There are further verses cited on the importance of learning Torah, and that's the end of chapter 1. Chapter 2 of Tractate Bava Kamma continues discussing the laws of damages. The first Mishnah says, the foot of an animal is muad, presumed to damage, meaning requiring a full payment if it damages by breaking things as it walks. If it kicked or pebbles shot out beneath its foot and it broke something, that's not muad, and it would require only half payment. If the animal steps on and breaks a utensil, and then the utensil falls onto a second utensil and breaks that also, the owner pays in full for the first and half for the second utensil. Chickens walking normally are muad also, meaning there would be a full repayment. If something was tied to its legs, or it was hopping and that's how it broke something, the owner would pay half damages. The Gemara suggests the main case of the animal walking was the main category of walking, and the second cases were subcategories. It argues seemingly contradictory wording from a later Mishnah, but that's explained to just be saying that a wild animal falls into the category of an animal. It further qualifies the particularities of the wording. We said damage via pebbles was a half payment, but others seem to debate this, saying it's a full payment, depending on the case. The one who says it's a full payment would hold that its force is like its own body, and the opinion that says it's a half payment agrees. They just hold it a half payment anyways, as it's a tradition from Mount Sinai. Additionally, some would hold if the contact between an animal and an object would be sufficient to make an object impure if contracted with a Zuv impurity, damages would be paid in full, and that's relevant by the case of a cow pulling a wagon. It's also taught if there's a rope holding a bucket in place and chickens peck at the rope until it snaps and breaks the bucket, the chicken's owner is liable to pay in full. It's asked if an animal steps on the utensil and it doesn't break, instead it rolls a while and then breaks. Is this considered as if the animal broke it itself, or is it similar to the case of an animal stepping on a pebble? Some hold, based on a related case, that a utensil that breaks is considered broken from the beginning of the process. If further debates proofs on this, according to the opinion that the pebble damages are paid in half, it asks if the payment comes from the body of the animal, or if you can also put from his best property. It argues on this from a number of sources. This is debated further. Additionally, the situation of a pebble damage, it asks if this is considered to be muad, a likely presumed damage, or otherwise, based on other points, it's compared to the horn category or to the foot category. This is argued on. Also, it asks if the damage is considered abnormal. It could only be a quarter payment, so it asks if this applies to pebble damages, and it's unresolved. It's also unresolved as to the status of the force, according to one opinion. It further qualifies the wording of the Mishnah, and it's also unresolved as to if there's liability if the path is on such a manner that an ox just can't walk without kicking pebbles. It's also asked if the animal is in a public domain and it kicked pebbles. It's asked if this is comparable to the horn category, meaning the owner would be liable, or to the foot category, where it would be normal behavior and there would be no liability. It debates this. It also asks about the liability of an animal knocking items over via swinging its tail around, or another appendage, the latter of which is unresolved. Regarding things tied to a chicken's legs, he pays half if they got tied there by themselves. If he tied it, he would pay in full. This is said to be particularly if a person tripped over the item the chicken brought, which has a similar status to a pit. New Mishnah. The tooth of an animal is muad, presumed to damage and requiring full payment. If it eats things it would typically eat, so fruit and vegetables essentially. It pays half if it eats clothes or a utensil. This is if it's on the damaged person's property. If this is on public property, he would not be liable. And if the owner benefited from the food, he repays what he benefited. Payment is considered to be for benefit if the food is in the middle of the street or at the entrance of a store. It's for damage if it's on the side of the street or inside a store. The Gemara cites cases of what it's typical for animals to eat, discussing these instances. For instance, a goat once climbed up a barrel to eat a turnip and broke the barrel and turnip. The owner was obligated to pay for both in full, as it was deemed normal for the goat to do those things. Also, it's said if an animal is in public and eats food on the back of somebody else's animal, it's considered like the second person's domain and he's liable to repay. It argues on sources. If there's straw in a private domain and it rolls into a public domain, it debates the status of this item. It also argues on the definition of benefiting from the food. Some say it's a reference to the value of straw, some say it's referencing inexpensive barley. It debates related principles by domain boundaries and similar. These are further discussed along with a few particular incidents. In regards to the animal eating from the sides of the street, some say it means the animal turns its head to the side and eats. Others say it's exempt if it does this, and it refers specifically to being liable where it actually left the center of the street and walked to the side. If the concern is the animal turning its head to the side, the case of the animal eating from a storefront where there's only a payment of benefit and not damages must be where the animal didn't turn its head. So it must be where the street narrows like this, with a storefront staying in front of the animal. Others say the opinions agree there's liability for the animal turning its head, and they argue about if part of somebody's domain was made to be a public domain. One saying the animal is not liable for eating from there, others say it is. This would be unlike an actual pit or something within its category, as either you're not responsible for a pit in your property, but you also could not expect others to be liable for you leaving your fruits within your public domain. Or you could say a person is liable for a pit that's in his own public domain, but a pit is not visible, unlike fruits which are visible, and there would be no liability. If it argues on the dispute of an animal turning its head to eat, whether the payment is for benefit or for damages. New Mishnah. If a dog or a kid jumped off a roof and broke utensils that it landed on, the owner of the animal pays full damages, as it was muad, presumed damage here. If the dog took a biscuit with coals stuck to it and walked to some hay, and the hay caught fire, the owner must pay in full for the biscuit and half for the damage. The Gemara debates if this creates an implication there's no liability if the animal accidentally fell off of a roof. Some say it would be specifically liable if it was on a narrow wall. It argues this concept based on related cases. In regards to the animal causing a fire, some say it's liable as the fire is deemed his generated force, others say it's as the fire is his property. The debate is as whether fire is considered to be your force, or if it can even be property, as it has no substance. According to the opinion that the fire is his property, he'd have to hold that the coal was tossed at the hay, and then he's liable to pay half for the exact spot where the hay was hit, but not for the entire haystack. It debates these principles from other cases. There are additional cases quoted to try to disprove the opinion that fire is legally considered to be somebody's property. Additionally, the opinion that holds fire is somebody's responsibility as it's his force also holds it's his property too. So there's a practical difference between the opinions if a person was injured from the fire, if he needs to pay the 4 forms of compensation. Also, the case with the biscuit refers to where the coal was guarded and the owner of the dog must pay for the biscuit. Specifically, as the coal is guarded, it must be that the dog burrowed into the house. This teaches that a latch door is still legally considered to be burrowable through by a dog. Additionally, the dog brought the fire to the haystack that was also owned by the owner of the biscuit. This would mean that the mouth of an animal in somebody else's yard has the legal status of the person's yard. This has to be legally specified, as otherwise you could legally argue that his food shouldn't be in the mouth of your animal. So, the way that the tooth category of damage from an animal functions, specifically in reference to complete destruction, this could include the animal damaging by rubbing itself against a wall, say to totally erase an image, or by rolling over fruits and crushing them. It debates the principle by the status of the animal's mouth from related cases. It was additionally ruled goats in a market that cause damage, their owners are warned 2 or 3 times, and if they don't restrain them, the man's required to slaughter and sell the goats. New Mishnah. A muad animal, which is presumed to be dangerous and must have its payment for damages paid in full, is when it was testified that it had damaged on 3 separate days. It reverts back to its original status when it doesn't damage for 3 separate days. Others say it becomes muad if it was testified about 3 times, and it loses this status if a child pokes it in the head and it doesn't gore anybody. The Gemara explains the logic of this dispute is based on verses. These are further discussed. It rules based on the opinion that an animal becomes a muad when testified on 3 separate days, and it loses the status going back to being a tom, actually like the second opinion, when it's provoked without goring anybody. It also asks, does the muad status go on the ox or on the owner? This is relevant if 3 witnesses saw the ox gore on 3 separate days, but they all testified to the owner on the same day. It debates this from sources. Additionally, it's asked, what if somebody had another person's dog attack another person? The inciter would not be liable. So it's asked if the owner of the dog is liable based on if he should be responsible for having his dog be like that. It has a number of cases to try and prove either way. Either way, if the victim had incited the dog against himself, the owner is not liable, as that's considered to be an irregularity. New Mishnah. An ox that damages on the damaged party's property is where it gored, pushed, bit, squatted, or kicked. If he did this in the public domain, the owner pays half damages. If it did this on the damaged party's domain, it's debated if he pays full or half. The logic of paying full is that if it was a tooth or foot category damage, he pays half, so this is more stringent, so he'd pay full. The logic that he pays half is that he paid half by a public domain, so he should also hear. They argue their logic further. The Gemara additionally debates the logic of these opinions from verses and similar. These principles are debated as to the different opinions, interpretation of verses. This is discussed. It's asked, according to these opinions, if an animal did a foot category of damage, stepping on a child in the damaged party's property, killing him, it debates as to the level of the repayment in such a situation, as the foot category is considered muad, something typically done, if it's comparable to the horn category of muad. It debates this and it says it would be comparable. New Mishnah. Anything a person does is considered to have the status of muad, whether intentional, unintentional, or if he's asleep or awake. If he blinds somebody or breaks something, he'd have to pay in full. The Gemara says, the grouping of damaging a utensil and somebody's eye teaches that if hurting the person was unintentional, he would not additionally pay the 4 forms of compensation for injury. Sources are cited. Similarly, for instance, if somebody was sitting with a rock on their lap and they did not realize it was there, and they stand and it falls on somebody, they would be liable for damages, but not for the 4 injury compensations. He also would not be liable for violating the Shabbos, and if he kills the man, he would not go into exile. And it's a dispute if the injured man was his slave, if he'd go free. If he was aware of the stone at first and then forgot about it and then stood, he is liable for damages and not the 4 compensations. He would be liable to go into exile based on a verse. He would not be liable for violating the Shabbos. And it's a dispute if the injured man was a slave, if he'd go free. If he meant to throw the stone only 2 cubits and it went 4, he'd be liable only for damages, not the 4 compensations. He would not be liable for Shabbos, he would not be liable for exile, and it's, again, a dispute by the slave. If he meant to throw it 4 cubits and it landed 8, he would be liable for damages, not the 4 compensations. He'd only be liable for violating Shabbos if he declared that it could land wherever it wanted. He's not liable for exile. And again, it's a dispute if it frees slaves. It's ruled if somebody throws a utensil off of a roof and somebody else smashes it with a stick before it hits the ground, the second man is not liable, as it's deemed as if it's already broken. Similarly, if somebody threw a utensil off a roof onto cushions and then somebody removed them before it hit the ground, the thrower is not liable. If somebody throws a child off of a roof and somebody else goes to catch the child with a sword, it's debated as to who's liable. It's also disputed who's liable if a muad ox caught the child on its horns. If somebody fell off of a roof and landed on a woman, accidentally cohabiting with her, he's liable for the 4 payments of compensation, and if it was a woman he needed to do yibum, the levirate marriage with, this is not a valid act of cohabitation. Specifically, he pays the 4 compensations of damage, pain, healing cost, and unemployment, but not for humiliation, the 5th payment here, as that's only paid if the damaging effect was intentional. Also, if somebody got blown off of a roof by an abnormally strong wind and he injures somebody, he's only liable for damages, but not for the 4 others. If it was a normal wind, he'd also be liable for the other compensations, but not for humiliation, as mentioned. If somebody places a hot coal on somebody's chest and the guy just left it there until he died, the placer is not liable for murder. If he put it on the man's clothes and it burned, he would be liable to repay, and it cites sources. It holds putting the coal on somebody's slave has the same legal status as putting it on the man's body, and putting it on the man's ox has the same status as putting it on his inanimate property. And that's the end of Chapter 2. Chapter 3 of Tractate Bava Kamma continues going through the different laws of damages and repayment. The first Mishnah says, if somebody places a barrel or a jug in a public domain, and somebody trips on it and it breaks, he's not liable to pay for it. If the guy who tripped hurt himself, the owner of the barrel is liable to pay him. The Gemara says there's inconsistency here as to the word used for barrel, but that's just because the words used have basically the same meaning. The difference is relevant regarding some laws of buying and selling. The man walking in the public domain is not responsible for breaking the pitcher, either as the whole domain was filled with the guy's pitchers, he tripped while it was dark, or it was just around the corner and he couldn't see it. Others debate this and simply suggest a person does not typically study the roads as he walks. It has some related incidents where this occurred. Related, if somebody knees somebody, they pay 3 salatim. If they kicked somebody, it's 5, and if somebody's hit with a donkey saddle, that's 13 coins. And it asks about the payment for striking with a shovel, but it's explained that that case was particularly where somebody was stealing from another person's water cistern, and this is like the opinion that a man can enforce the law if it would have resulted in a loss for him. Others disagree with this principle, and they debate. It discusses related proofs for these opinions as to whether or not a person can take the law into his own hands in unique circumstances. New Mishnah. If somebody's pitcher of water broke in a public domain, and somebody slipped on the water or was injured by the pitcher, some say the owner is liable to pay, others say he's only liable if he had intent. The Gemara says if he slipped on the water, he'd be liable to repayment if his clothes got ruined by the water, but not if he hurt himself on the ground, as the ground is ownerless. Others dispute this. It's disputed if an owned hazardous object left in a public domain, classified as an ox category or a pit category, depending on whether he's liable for damaging utensils. Based on this, they dispute if somebody carrying a jug tripped on a rock as to whether the rock owner would be liable if the jug broke against the ground or against the rock. We said if the owner of the jug had intent, he's liable, which is said to refer to if he intended to set down the jug and tripped and it smashed. The stricter opinion would say he's liable even if it disintegrated while he was holding it. Others dispute this. It discusses related cases. If the case is where the man declared the hazard ownerless but still had intent, some say it refers to where he's liable if he intended to regather the shards. It also disputes as to the liability for damage after the individual fell. There's discussion on this. There's a more specific debate as to if somebody declared his hazardous object to be ownerless, if he's liable for it, and it discusses the logic behind these opinions and what they would hold in some particular listed instances. New Mishnah. If somebody pours water into a public domain, and somebody's damaged by it, the owner is liable for this damage. If somebody hides a thorn or glass in a public domain, or if somebody makes a fence out of thorns, or if the fence falls into the public domain and people are damaged by these, the owner is liable to pay. The Gemara suggests the person who slipped on the water is liable to pay if the clothes are damaged by the water and not by the ownerless ground injuring somebody. This is as the cases where the water was absorbed into the ground already. Now, this was already said earlier, however, it repeated it here again to show that this law applies whether it's in a summer or in a rainy season when pouring water in public is allowed. In regards to hiding thorns or glass, he's not liable if he did it in his own wall, as people don't typically brush up against walls. If he did it within somebody else's wall, and it was then demolished, causing the sharp objects to enter a public domain, he's liable if it was a rickety wall, as he should have expected it to be demolished. If it was a sturdy wall, only the owner of the wall is liable. It specifies proper methods of disposal of sharp objects. New Mishnah. If somebody leaves out his straw to be converted to fertilizer, and somebody was hurt by it, the owner is liable, and anybody is allowed to take this straw. Others say, generally, somebody who makes a public hazard must pay, and anybody can take the object. If somebody turns over feces in a public domain and somebody is damaged by it, the person who did this is liable. The Gemara says some dispute the first point, possibly, and they argue citing cases. In regards to taking the item, some say you can take the actual item, some say you can only take improvements to the item based on where the penalty applies. So they dispute this based on various sources. New Mishnah. If two men were walking with each other, and the first man trips, and the second man trips over him, the first man is liable to pay the second. The Gemara says, there could be an argument as to why he's liable, either as the first man's tripping was negligent, or as he just hadn't gotten up when he could have. Others say he couldn't have gotten up, but he could have at least warned the other guy verbally. Others say that's not valid, as he's preoccupied with having just fallen down. It tries to cite proofs as to what the issue is here. This is discussed, and it says if a second and third person fell due to the first person would be liable. This could be possible, as the first guy is lying blocking the entire road in some variant. New Mishnah. If two people are walking in a public thoroughfare, one with a beam and one with a jug, and they bump into each other, and the beam breaks the guy's jug, he's not liable, as they both are allowed to walk there. If the owner of the beam was in front, and the jug owner walked fast and bumped into the beam, breaking his own jug, the beam guy is not liable. If the beam owner stopped short and the jug broke, the beam owner would be liable, but not if he yelled stop. If the jug owner was first and the beam was going fast and he broke the jug, the beam owner is liable. If the jug owner stopped short, he is not liable, and if he yelled stop and the jug in front broke, the beam owner is liable. This all applies with a lamp and flax. The Gemara asks if somebody accidentally injured his wife while cohabiting. It asks if he's liable based on our discussion, where the walking in the area was permissible, but others dispute this comparison, and it qualifies the individual cases. New Mishnah. If two people are on a public thoroughfare, one running and the other walking, or both walking, and they injure each other, neither are liable. The Gemara says, some argue saying running is an irregularity, besides for on Friday night. It's suggested that that's what specifically the Mishnah was referring to. It cites sources here that you can run by Shabbos. Here. New Mishnah. If somebody is chopping wood in a public domain and accidentally damages somebody's private domain, or he chops wood in a private domain and damages a public domain, or chops wood in a private domain and damages another private domain, he is liable. The Gemara says it's stated in all three cases, as there's variation. If it's into a public domain that has lots of people, if he's doing it in a public domain, he doesn't have permission, and the private domain to private domain is specified as it has neither of these factors. It said if a person enters a carpenter's workshop without permission and a piece of wood hits him in the face and injures him, the carpenter is not liable. But if the man entered with permission, it says he would be liable. He'd be liable to pay the 4 compensations, but not to be exiled based on the verses. It disputes the last point as to what the status is if he kills the guy, as to how unintentional it's considered to be. It argues on this from various cases, and this is discussed. New Mishnah. If two tam, non-dangerous oxen were fighting, and they both injure each other via a horn category, they pay excess half damages. If both were muad, established to be dangerous animals, they pay excess full damages. If one was tam and one was muad, if the muad's damage was greater, he pays excess full. If the tam's damage was greater, he pays excess half. If two people injure each other, they pay the excess full. If a person and muad animal damage each other, whichever did more pays the excess full. If a person and a tam animal damaged each other, if the person's damage is greater, he pays the excess full. If the tam animal's damage is greater, he pays excess half. Others say if the tam animal injured the person more, the owner would pay the excess full. The Gemara cites sources for these principles. New Mishnah. If an ox worth 100 coins gored an ox worth 200 coins, and the carcass is worthless, the damaged party can take the living ox. The Gemara cites the author of this based on his opinions about these laws. Others do disagree, some saying the court sells the ox, others saying the damaged party and damager sell the ox. There's a practical difference if the damaged party consecrated the ox. It asks, what if the damager sold the ox? It said this is invalid, and the other man can collect payment. It's further qualified, discussing some particularities, and there are additional points in all this. New Mishnah. An ox worth 200 coins, if it gores an ox also worth 200 coins, and the carcass is worthless, the verse says to sell the live ox and split the money, so they share the loss. A verse also says to split the value of the dead ox, but that's where the carcass is worth 50 coins, and they split the value of both oxen. The Gemara says some dispute this. It's suggested they argue with how the animal carcass is valued. This is further disputed along with sources. New Mishnah. There are some theoretical actions that a person would be liable if he himself does, but not if his ox does them. For instance, if a person humiliates somebody, he'd be liable, but if his ox humiliates somebody, he's not liable. Or, if he injures his slave, he is liable, but not if his ox does it. The inverse also applies. There are things that if his ox does, he's liable, but not if he himself does them. For instance, if his ox injures his parents, he's liable to pay them, but not if he does it himself, as he receives the death penalty for that. Or he's liable if his ox sets something on fire on Shabbos, but not if he does that, again, as there was capital punishment for that violation. The Gemara says, some hold that you're exempt if you do a destructive act on Shabbos, unless you wound or burn something. Others disagree based on our discussion. This is discussed. Some suggest our case of setting an item on fire on Shabbos, he'd be exempt even if it was unintentional, according to one opinion, so long as he requires the ashes. New Mishnah. If an ox was chasing an ox, and the second ox was later found to be damaged, and they debate if the injury was caused by the first ox or not, or possibly by some rock or something else, the burden of proof is on the person who's trying to get the payment. If two oxen were chasing an ox, and they argue which ox did the damaging, both are exempt. If both belong to one person, then both are liable. If they dispute which ox did it, either the big one or the small one, for instance, or the tam or the muad one, which would change the payment amount, the burden of proof is on the one trying to get payment. If there were two damaged oxen, a big and small one, and two damaging oxen, being tam and muad, and they dispute as to which oxen damaged which oxen, the burden of proof is on the one trying to get payment. The Gemara says this seems to disagree with the opinion that money whose ownership is in doubt is divided, which would apply even if both litigants made a definite claim. Others say it wouldn't apply there, and it's where one is certain and one is not. It's disputed as to which the cases are referring to, and this is further argued. In regards to where both damaging oxen belong to one man, and they damage a single ox, it disputes if this refers to tam or muad oxen, and it says it's tam, meaning both oxen are required to be present to collect the payment, as it could have been either one of them. And that's the end of chapter 3. Chapter 4 of Tractate Bava Kamma continues on the various laws of damages. The first Mishnah says, if an ox gores 4 or 5 oxen, but at irregular intervals, so it remains a tam, an animal not established as dangerous, meaning it would only require a half payment if it damages something, the last gored ox is paid first. If the goring ox is worth more than the payment, the excess is given to the second to last damaged animal. If there's still excess, it goes to the next prior animal. This opinion holds that the later damaged animals are repaid first. Others say the owner of the goring ox and the victim both must pay the damage. If a tam ox worth 200 coins gores an ox worth 200, and the carcass is worth nothing, they both receive 100 coins of value. If the ox then gores another animal worth 200, the latest gored animal takes 100 coins of the tam ox's value, and the owner and the preceding victim both take 50. If the ox gores another animal worth 200, the latest damaged party gets 100, the prior gets 50, and the owner of the tam ox and the first damaged guy both get 25 coins. The Gemara discusses the authorship of the first part in accordance with various opinions. It's explained it's like the opinion who holds that the damaged parties are legally considered to be creditors. However, based on the wording, it must be that each successive victim grabbed the goring ox to collect damages from it. So essentially became like a legal paid custodian, and then it gored the next guy's ox, which is why the last guy collects first. It's further amended to fit like this. The second clause of the Mishnah would be in accordance with the differing opinion. Based on a related discussion on a debate if somebody punches somebody in the head, if he owes him a sella or a mana, it tells that any silver referenced in verses from the Torah is accounted in Tyrian currency, and any amount of silver in rabbinic legal matters goes by the provincial currency. It quotes some related incidents on this. New Mishnah. If an ox is muad, established to be dangerous for some things but not for others, for instance muad towards its own species but not towards other species, or muad towards people but not towards animals, or muad towards young animals but not old ones, it pays the full muad charge for goring animals that it's muad towards, and half payment for other animals. If it's muad towards specific dates, like it gores specifically on Shabbos, it would be muad on Shabbos and not on a weekday. It could revert back to a tam here if it goes 3 Shabbosim without goring. The Gemara debates particularities on the wording as to if the ox is known to be muad towards some species, but they're unsure regarding others, whether it's assumed to be muad for everything too. They debate this principle further. There are particularities of establishment of a muad mentioned. If an ox gores alternative oxen, it's established to be muad to gore alternatively, and it can also gore different species alternatively. If it gores an ox, donkey, and camel, it asks if the last ox goes with the first two or the last two, along with a similar question if it gored a donkey, camel, ox, and ox. And a similar question if it gores Shabbos, Sunday, and Monday, or Thursday, Friday, Shabbos, as to where the middlemost animal lies, and they're all left unresolved. If the ox gored on the 15th of the first month, and the 16th of the second, and the 17th of the third month, it's debated, similar to by the establishment of a nida period, if this is muad, or if it needs to gore an additional time to establish this. If the animal gored 3 separate times right after hearing a shofar blown, it's established as muad by a shofar. Even the first one counts, and it's not considered as if it just got scared. New Mishnah. If somebody's ox gored an ox of a temple treasury, or vice versa, the owner is exempt, as the verse says, if the ox of a man strikes the ox of his fellow, implying no liability involving the temple treasury either way. If the ox of a Jewish person gores the ox of a Canaanite specifically, he is exempt, and vice versa. Whether tam or muad, he must repay him. The Gemara debates the verse, implying the lack of liability within the temple treasury for being damages or damaging others by their oxen. Others say it implies the inverse, that a person is liable to pay in full, whether it's tam or muad, if his ox damages the temple treasury. Based on this verse, additionally, these monetary laws apply specifically to Jewish people. So it says technically everybody else should be exempt, but it was said that as the Canaanites refused to keep the 7 Noahide laws, they had to, at the very least, abide by the monetary laws. It cites verses as sources for this concept. It debates what reward non-Jewish people receive for fulfilling commandments. It says that if a non-Jewish person studies Torah, he's considered as great as a Kohen Gadol, a high priest, and it's said that they don't receive a reward for fulfilling commandments that they were commanded to do. They instead receive reward for fulfilling commandments they were not commanded to do. It said the law of one-sided lack of monetary obligation was taught to officials of the Roman government along with the entire Torah, and they said they agreed with everything besides for this one portion, but decided to not tell the authorities about it to be nice in case people got upset. So essentially what it seems to be saying is that non-Jewish people don't really have any applicability within Jewish monetary law, meaning there would be liability for a non-Jewish person's damage, but not vice versa. And evidently, as it states here, this was clearly a very controversial point. However, it would be important to note that this no longer has application, as the Gemara later establishes the principle of dina de malchusa dina, the law of the country is the law, literally, which essentially means that there is a religious obligation to abide by the laws of whatever country you're in. So practically, monetary law has applicability towards everybody both ways, with no exceptions as the country decides. It discusses some related verses on the lack of commandment to fight against Moabites and similar, along with additional similar principles with Kuthians, specifically by lack of liability for monetary damages, along with debate if they're considered to be proper converts. New Mishnah. If the ox of a mentally competent person gored the ox of a deaf-mute, insane person, or minor, or vice versa, the owner is exempt. If the ox of a mentally incompetent person gored something, the court appoints an agent to watch the ox, and the court accepts testimony regarding it before the agent. If the muad ox was being kept by the agent, and the deaf-mute becomes able to hear and talk, or the insane person becomes sane, or the minor becomes an adult, it's debated if the ox reverts to tam or stays as a muad. An ox of an arena that killed a person is not liable to be killed, as the verse implies an exclusion of oxen made to gore things. The Gemara explains an apparent contradiction as to if the agent is appointed by a tam to collect the half payment between clauses, so it explains the second clause is where the animal is being considered to be a muad. In regards to the appointment of an agent, it debates as to whether the best quality produce is taken from orphans or from their agent. Some say it's from the orphans, as then people won't become agents. Others say it's from the agents, as they're repaid once the orphans become adults. It further debates if the court appoints an agent to allow the damaged party to collect payment by a tam, based on several other cases. There's additional discussion on these principles. Also, it said the agent would need to pay if the ox he's watching killed somebody, but he would not need to pay for atonement, which is an additional amount for the death of the individual, as the orphan doesn't need to pay atonement. It argues as to who holds this opinion. It also debates as to how this value is assessed and whether this payment is paid if the ox that killed somebody was owned by 2 people, or whether they give 2 half payments. It also asks if security is taken from somebody who needs to pay this obligation. In regards to the point of the animal's muad status reverting if it changes ownership, it said if somebody borrowed it and it was a muad, the borrower and owner both pay half damages. If it became a muad under the borrower's care and is returned to the owner, the borrower would then be exempt and the owner pays half damages. The logic of this is debated as to if the borrower needs to presume the ox was a muad. This is further discussed. It also debates if an ox of an arena can be used as an offering or not. It argues on this from various sources. It quotes a source which says an arena ox is not liable to be put to death if it kills somebody, and it is valid as an offering as it's considered as if it was coerced. New Mishnah. If an ox gored somebody and killed them, if it was muad, the owner pays the atonement fee called kaifer. This is not paid if the animal was tam. Either way, the animal was put to death. This also applies if the killed person was a child. If the ox gored a slave or maidservant, it's stoned, and the owner gives 30 sala'im to the owner of the slave, no matter the worth of the slave. The Gemara asks, how is there a case where there's a muad ox if oxen are killed when they're tam, apparently? So it says that the ox attempted to kill 3 people here, which is why it's being executed. Others disagree, saying you can't assess an animal's intentions, so it must be that it either mortally wounded 3 people or killed a person, ran away before it could be recaptured, and then repeated. Or it's where the witnesses were discredited, or it's where the witnesses recognize the owner but not the ox, and the owner is responsible to at least watch all the cattle. It cites the verse saying the animal that kills a person is put to death, and also that the animal can't be eaten from after or benefited from. It further expounds on these verses, which teach these points. These are discussed along with similar related points. It qualifies the point on the set sum repayment for an ox killing a slave. It discusses additional verses which show a man or woman have repayment given if they're injured and their damages are repaid in a similar manner, in regards to inheritance if they die. There are further points here, and it says if the ox killed a slave on accident, there's no necessity to pay the set 30 coin fine, and it cites a verse as source. This also applies with the kaifer payment if a regular person is killed, that it's not given if the ox killed the man accidentally, and it cites sources. Others debate this. Some suggest if there's no kaifer or 30 coin fine, there would still be the general damages payment. This is argued on based off of discussion of additional cases. It has unresolved points if this is comparable to a fire unintentionally killing somebody. It further debates if there's liability for kaifer payments based on verses. It also quotes verses saying the ox is killed, and there's kaifer payment even if the ox kills a child. It further debates over the sources for these laws. New Mishnah. If an ox rubbed itself against a wall and the wall collapsed, killing a man, or if the ox was trying to kill an animal and accidentally killed a man, or to kill a Canaanite and killed a Jewish person, or tried to kill a non-viable miscarried baby and killed a viable one, the ox is exempt. The Gemara debates if the ox is exempt from being put to death, but not the kaifer payment, or if it's exempt from both. There would be liability of kaifer, as the ox is a muad to knock walls onto people specifically, and it didn't intend to kill a man. It was just rubbing against the wall for enjoyment to scratch itself, which is known as it kept using the wall after it fell. Also, the ox must have been moving constantly against the wall as it fell, so it's not a case similar to pebbles knocked around as the ox walks, where there would not be a kaifer liability. We cite a source which states that there would still be a kaifer liability even when the ox kills unintentionally. There is a debate if there's liability for payment if an ox accidentally injures somebody based on if the laws are learnt from whether the ox pays kaifer or from the laws of if the ox is put to death. It debates as to the liability if the ox tried to kill one person but accidentally killed a different person. New Mishnah. The ox that belongs to women, orphans, or the guardian of orphan children, or a wild ox, a consecrated ox, or the ox of a convert without heirs, are all liable to be put to death if they kill somebody. Others say those last 3 are exempt as they're ownerless. The Gemara cites scriptural sources for these points. Also, it says if an ox was consecrated after it gored, this would evidently imply it's also not put to death, and it cites sources. New Mishnah. An ox that's being taken out of a courthouse to be stoned, and it's consecrated then, right there, at that point, it's not a valid consecration. If it was slaughtered, the meat is prohibited from benefit. If it was consecrated before the verdict, it's a valid consecration, and if it was slaughtered, it can be benefited from. New point. If an owner left his animal with an unpaid guardian, a borrower, a paid guardian, or a renter, and the animal damaged something, the person taking care of the animal currently makes the payment, be it full for a muad or half for a tom. The Gemara cites a similar point. Although, if a guardian returns the animal to the owner after the guilty verdict, it's debated if this is valid as to whether this returned item has worth. Others say it is allowed, as it's similar to, say, a thief returning chametz, leavened bread, after Passover. And the dispute is actually whether the court can judge the case of an ox if the ox isn't actually there, which would make a difference with the original owner, as if he had received it first, and the court needed the ox there to judge, he could have chased the ox away so that way it wouldn't suffer prosecution. In regards to the different levels of guarding the animal, it must be where he was guarding the animal with a lesser form of guarding, so that way there's no negligence, and the unpaid guardian would be legally fulfilling his obligation. Further, it's held if an ox was being watched by an unpaid guardian and it damaged others, the guardian is liable, but if it was damaged by others, the guardian is exempt. This must be where the guardian accepted responsibility for the ox's damage, but didn't think that others would damage it. New Mishnah. If the owner tied his ox with a rein or locked it properly within a gate and it broke out and damaged, it's agreed he is liable if it's a tam ox, and disputed if it's muad. Some say they're liable if there were lesser forms of guarding it, others say these suffice, so he'd be exempt, and others say they're liable no matter what, and it must be slaughtered. The Gemara explains the debate further as it's based off of some scriptural verses. The fourth opinion holds that the owner is exempt whether it's a tam or muad, as he agrees it's exempt if it's a muad, so logically then it should be for sure exempt if it's a tam. Some say this opinion would hold that if it was actually a muad ox, he'd still have to pay half payment. Others disagree with this. It cites verses that say the muad ox must be slaughtered, along with additional sources. And that's the end of chapter 4. Chapter 5 of Tractate Bava Kamma continues on the laws of damages. The first Mishnah says, if an ox gored and killed a cow, and then they find the fetus dead next to the cow, and they don't know if the fetus was born before or after the goring, the owner of the goring ox pays half damages for the cow and quarter damages for the fetus. If the cow killed the ox and they find the cow had given birth and they don't know if it was before or after its mother had killed the ox, half the cost of the damage is paid from the cow, and if it's insufficient, then also a quarter is paid from the offspring. The Gemara says, this is unlike the majority opinion of the major principle that the burden of proof lies on the one wanting payment. It calls this a major principle to show this applies even if the damaged individual says the other is definitely liable, and the damager says he's only possibly exempt, then the damaged party still has to bring proof. Others say the major principle point is to show that the opinion that if somebody sells an ox and the purchaser finds it's a dangerous goring ox, the sellers can just say it doesn't matter, it's a valid sale, as they sold the ox to be eaten. Others dispute this, particularly where the person commonly purchased oxen either for work or for food. Others add it's where the price of meat was the same as where the price for a working ox was at, so that way in this case you won't be able to determine its intended use based off of the purchase value. It additionally qualified anyways. Some say it's an invalid sale, as majority of people purchase oxen for plowing. Others say that that doesn't apply by monetary law, so the purchase would actually stand. As for the principle that the burden of proof lies on the one desiring payment, we cite scriptural sources. By the cow goring, it says half and a quarter are paid for the child. However, it's a tam, so others say it actually means a quarter and an eighth payment. Specifically, it would also need to be where the cow and offspring were owned by two different people, so that way there actually would be two separate payments. Further, the damaged party must have requested payment from the other owner of the offspring, thereby claiming the two separate payments from two people. Others say it would work to ask the mother's owner first. Others dispute this. Some say it's simply where the cow and offspring are actually owned by one singular person, and it's referring to two cases of collection, one where the cow is there, where it's collected from the cow, and one where the cow is missing, where the payment is collected from the child. This is further qualified. Additionally, the offspring and cow's value are assessed together, so it's accurate, and it's similar instances. Another point, if it's obvious that the cow and offspring belong to different people, and the cow miscarried from being gored, the compensation for the fattening of the cow from pregnancy goes to the cow owner. The increase in value for the expansion of the cow's body is split between them. New Mishnah. If a man brought pots into somebody else's courtyard without permission, and the courtyard owner's animal broke the pots, he's exempt. And if the animal was damaged, the pot owner is liable. If the pot owner had permission, the courtyard owner is liable if they're broken. It's a similar case of leaving food in somebody's yard with or without permission, and the owner's animal eating it. There's also an instance if somebody left his ox in somebody's yard without permission, and the yard owner's ox or dog attacked it, he's exempt. And if the first man's ox attacked his animal, he'd be liable. If the impermissible ox fell into a cistern, ruining the water, he'd be liable. And if it killed the owner's relative, he'd also need to pay the kofar reparations. If he had permission to leave his ox there, and it got hurt, the yard owner would be liable. Others say, with all of these cases, the yard owner is only liable if he expressly accepted responsibility to guard the item. The Gemara tries to infer that if the item was there with permission and it damaged something of the yard owner's, he'd be exempt, which is debated based on who holds that interpretation. If the man impermissibly left his produce, we said if it injured an animal, he's liable. This applies if it slipped on the food. If it ate too much and died, he would not be liable, as it's not his fault that it ate it. Others disagree with this. Others respond by saying he's only liable if the food was poisoned. This is further debated. It also asks, if the yard owner accepts responsibility to guard the item, is he only obligated to guard it from himself specifically, or from everything in the world? It discusses this from various sources. This principle is debated further from additional locations. It said if somebody's ox is in somebody's yard without permission and it digs a pit, the ox owner is liable to pay for damage to the yard, and the yard owner is liable to pay for anybody damaged by the pit, as he didn't fill it in. Similarly, if somebody's ox is in somebody's yard without permission, and the ox specifically crouches to the ground, and it caused damage in that manner, the owner of the ox would be exempt. It explains that this notion of the animal crouching is specifically in reference to the animal using the restroom, as the waste would have a similar category of a pit, especially as nobody retains ownership over it. Related, if somebody enters somebody else's yard without permission, he's liable for any damage he does to the yard owner, and if the yard owner damages him, he'd be exempt, so long as it was unintentional, as he's allowed to evict him, not injure him. Regarding the ox falling into a cistern and ruining the water, that applies if the water was ruined at the moment it fell in. This is because after this point, an ox that falls into a cistern has the legal classification of a pit, and the cistern itself has the legal classification of a utensil, and there's no liability for a pit damaging a utensil. Others debate this, saying it only becomes classified as a pit if it's made ownerless, so rather it refers to exemption if the animal's smell damaged the cistern, as it created a causative damage, which has no liability. Regarding the ox killing a person, specifically by falling on them in the cistern, it must be a muad ox to pay kofer. So either it's muad for falling into people in pits, and the prior times it was unintentional, or it's like the opinion that a tom still pays half kofer, or it's like the opinion that an animal doing horn category of damages on somebody else's property pays in full with kofer. It debates who the law is like as to if the landowner is liable for damage to the animal even if he didn't specifically take responsibility for it. This is discussed. New Mishnah, if an ox tries to gore another ox but accidentally hit a pregnant woman and she miscarried, the owner of the ox is exempt from paying liability for the miscarriage. If a person intended to hit somebody and accidentally hit a pregnant woman, causing her to miscarry, he would be liable for the miscarriage. This value is calculated by the value of the woman prior to giving birth and how much she's worth afterwards, and he pays the difference. Others say a woman actually increases in value after she gives birth, so he gives the value of the actual miscarriage. The damager would give this payment to the woman's husband. If she has no husband, she gives it to his heirs. If she was a freed Canaanite maidservant or a convert, the damager is exempt. The Gemara says this would imply that if the ox did intend to gore the pregnant woman, the owner would be liable, although others debate this. It's also said if an ox gored a pregnant Canaanite maidservant, the owner would be liable, as a slave was legally considered to be property, and essentially analogous to a gored animal. It further qualifies how the value of the miscarriage would be calculated. This is discussed further with related points. New Mishnah, if somebody digs a pit in a private domain and opens it also into a public domain, or vice versa, or from his private domain into another private domain, he's liable for any damages. The Gemara says based on verses, either the pit being referenced in scripture is a pit in a private domain opened into a public domain, and according to others, it's a pit dug in a private domain and the ownership of the land surrounding the pit is made into public property. These opinions debate each other along with further on digging pits in a public domain, including the story of Reb Chanina ben Dosa and the child who fell into a well, which was said in an earlier tractate. It also says not to knock stones from your own domain into the public domain, and there's a story where somebody was doing this and he was criticized, and he ended up tripping over the stones that he had left out in the public domain. New Mishnah, if somebody digs a pit in the public domain and an ox or donkey falls inside, he's liable to pay damages. This liability applies if it was a pit, ditch, vault, squared pit, or wedge pit. It mentions specifically a pit, which has a minimum depth of 10 handbreadths to cause death and to be a danger, which would therefore apply as the minimum depth for any other obstacle. If it was less than this amount and the animal fell in and died, the pit owner is exempt. If the animal was injured, he would be liable. The Gemara says the scriptural liability of the pit is from the foul air that extends from it, and it debates if this includes a scriptural liability for impact, which creates a difference if there's a liability for damage from elevation. This is debated from verses. It discusses the necessity of specifying the different types of ditches along with the establishment that 10 handbreadths creates a minimum concern of death, and any less than this creates a concern for injury. It said that an ox becomes fatally injured and no longer kosher if it falls into a pit 6 handbreadths deep. Based on the height of the ox, this must be at least a distance of 10 handbreadths. So technically there's liability if it falls into a depth of 6 handbreadths, but our Mishnah specified 10 to include liability if the animal rolled in. New Mishnah. If there's a pit owned by two people, and both, one at a time, walk by the pit without covering it, the second person is liable. The Gemara says the instance of two people owning a pit can fit like the opinion that says the described case is where somebody dug a pit in his own property and then gave up ownership of the area around it, as they both could have owned the property prior to making it public. However, according to the opinion that there's liability if the pit was dug in a public domain, how could two people own this pit? It's explained it's possible where the pit was dug in a public domain 9 handbreadths, and then the last handbreadth was dug by both of them simultaneously, so they share liability for death and injury. Others debate this and say, based on verses, only one person would be liable, specifically the second person. There's a similar debate by a 9 handbreadth deep pit that somebody places a 1 handbreadth rock by the ledge, even though that isn't the depth that would cause foul air damages, according to that opinion. If somebody did both, removing the bottom handbreadth and filling in a handbreadth at the top, it's unresolved if he's liable. If somebody dug 8 handbreadths, and the bottom 2 are filled with water, in regards to generating foul air, every handbreadth of water is equivalent to double. So it's unresolved if this would still apply with 9 and 1 handbreadths of water, or 7 and 3. If somebody widened a pit, it said he's exempt if somebody is harmed from the foul air, and he is liable if somebody is damaged by falling into it. It's debated if there's bad air generated if the depth is greater than the width, or vice versa. In regards to two owners of a pit not covering it, some say the first person becomes exempt when he leaves it with the second one. Others say it's from when he hands the pit cover to the second person. This is debated further based on the principle of retroactivity. It also says when somebody is selling a pit, the other man acquires the pit once he receives the cover as a proprietary act. It cites related acts of acquisition. New Mishnah. If two people owned a pit, and the first used it and covered it, but it somehow got uncovered, and the second person used it and didn't cover it, the second person is liable. If somebody covered a pit, and an animal somehow still fell in and died, he is exempt. If he hadn't covered the pit properly, then he'd be liable. If an animal fell forwards into a pit because it was startled by the sound of somebody digging, he'd be liable. He would not be liable if it fell in backwards. If an ox with utensils fell into a pit, the pit owner is liable to pay for the animal, but not for the utensils. If an ox that's deaf, deranged, or young fell into a pit, the owner is liable. These liabilities only apply to animals. If a child, or a Canaanite slave, or a maidservant fell into a pit, the owner of the pit would be exempt. The Gemara says in the first case, with the partners owning the pit, some say the first man becomes liable if enough time has passed that he should know that the pit was uncovered. Others say it's enough time for people to have told him that the pit was uncovered, and others say it's enough time for people to tell him and him to cut down trees and hire workers to make a new cover. The instance where there was a cover, but an animal broke through anyways, was where it was rotted away and wormy on the inside. It asks if somebody's pit cover was strong enough to hold oxen, but not camels, and camels came, walked over it and damaged it, and then oxen walked over, broke the cover, and died. It asks whether the owner is liable. It debates if this is referring to where the camels are common or not. It lengthily debates as to what the case is exactly referring to. It learns from a different case that the negligence of the owner is only applicable to the specific damage that occurred. In regards to the animal falling because of noise, he is liable if it falls forward, and exempt if it falls backwards. Some say both of these refer to it falling into a pit, with forwards being the liability for the bad air, and backwards being liability for impact damage. Others say impact damage is also a concern, and falling forward alone is where it falls into a pit. Falling backwards is also where it fell towards the pit, but fell backwards, hurting itself on the outside of the pit. They debate these opinions and cite sources. These are discussed further. There are related principles on multiple parties damaging. If an ox and a disqualified offering ox gored an animal together, some say the owner of the regular offering pays a full muad, some say only half tum liability. If an ox and a person push somebody into a pit, so now there are essentially 3 partners in this damage. All are liable, but the person that pushed is liable to pay for the 4 compensations and for a potential miscarriage. If it was a kofer death payment or 30 coins for a slave, that would be paid by the ox owner. And if it was a utensil or ox that's disqualified for an offering that was damaged, the person and ox are liable. Sources are cited for these principles. These sources are discussed further as to the exact reference liabilities for all these damages. It also clarifies the point on the ox being mentally incompetent that still creates liability if it falls into a pit, unlike by a smart animal, as it should have seen where it was going, meaning there's no liability if it was a smart animal that fell into a pit, particularly in the middle of the day, where it could see. New Mishnah. The general laws of an animal falling into a pit don't just apply to an ox, but also to any domesticated animal. Additionally, in spite of the verses only mentioning particular animals as example, all of the laws of the separating the animals away from Mount Sinai, the double payments made after stealing an animal, returning a lost animal, helping unload an animal, the prohibitions of muzzling an animal as it threshes, the prohibitions of forbidden mixtures of animals, and the prohibitions of having animals work on Shabbos, All of these apply to all animals, including wild animals and birds. By these cases in Scripture, it specifically says ox or donkey, as Scripture customarily references the typical usual cases. The Gemara additionally cites the sources for all these different laws, quoting the individual scriptural verses. It further expands on the verses and related, and it teaches that if somebody sees the letter tes, which looks like this, once in a dream, it's a good omen, as is seeing the word hesped in writing. Additionally, in regards to the laws of forbidden mixtures, it said that a chicken, peacock, and partridge are all different species and cannot be mixed in spite of the fact that they typically live together. Also, domestic geese and wild geese are separate species by these laws, as they have slightly different reproductive organs and processes. The laws of forbidden mixtures also apply to aquatic animals, and outside sources, it does debate as to, for instance, if you can have a goat and a large fish pulling a wagon together. And that's the end of Chapter 5. Chapter 6 of Tractate Bava Kamma discusses the laws of damages, particularly on the supervision of animals. The first Mishnah says if a sheep was properly fenced in and locked into a field, but it escaped and damaged somebody's property, the owner is not liable to pay for damages. If he did not lock the gate properly and it escaped and damaged somebody's property, he would be liable. If it was locked properly but it escaped at night, or robbers broke the fence and it escaped, nobody's liable. If the robbers took the sheep out, they're liable. If he left it in the sun so that it gets uncomfortable or with a mentally incompetent person and it escapes and damages something, the owner is liable. If he gives it to a shepherd, the shepherd holds all responsibility. If the sheep somehow accidentally fell into somebody's garden and ate their produce, the owner of the sheep repays what it benefited from. If it intentionally walked in, the owner pays for what it damaged. The damage payment is assessed by calculating the difference between the area of the field before and after it was damaged. Others say if it ate ripe produce, he'd have to repay the value of the produce itself, as if it had been harvested. The Gemara says a properly locked gate is one that won't open from a common wind. Otherwise, it's considered to be improperly guarded. It debates, according to different opinions, as to the level of guarding required for the different forms of animal damages between the horn category, tooth, and foot categories. It cites a number of additional unique cases where there's technically a violation, but a lack of liability. There's debate as to the circumstances of the case where the animal escapes past the fence at night, as to if there's a degree of negligence, even if it dug beneath the proper wall, and variation as to if it had been left out in the sun, if this creates a degree of negligence to the point where if the animal escapes, it's considered to be the owner's fault. If the robbers let the animal out, they'd even be liable if they didn't pull it. They just stood in front of it. In regard to a shepherd, it said he doesn't take the place of the actual owner. He actually takes the place of a watchman, even if he's only an apprentice. There's variation of this. Additionally, if somebody's watching a lost object, it's debated if he's legally considered to be an unpaid custodian, as he has no benefit from it, or a paid custodian, as he's not obligated to give bread to the poor as he watches it, which is technically a form of benefit. Others say it's because the Torah obligates him to do this, even if he doesn't want to. They debate against each other from various sources, and this principle is additionally discussed. Additionally, by the animal falling into a garden, it's said that even if it benefits from falling onto the produce, the owner is liable to pay for that also. It debates as to what's considered an accidental fall. Some say it slipped on something, such as its urine. Others say it's if an animal pushed it. The first opinion would disagree with the second, as he would hold that's a negligent way of leading animals. If he ate produce after falling in, the payment is for benefit. However, after, if it walked around and ate from other beds, he'd also be responsible to pay for those damages. Others dispute this. If the animal walked into somebody's garden normally and then gave birth, soiling the plants, it debates if there's liability based on the degree of negligence here. It's unresolved. It gives scriptural sources for the opinions on how the payment amounts for these fields are evaluated. These principles are discussed further along with related particular incidents. These laws are additionally qualified in regards to variation of value assessment by harvesting various specific types of plants, according to the opinion that the liability of payment is assessed from ripe fruits, as if they were harvested. It cites sources for this. New Mishnah. If somebody piles stacks of grain in somebody's field without permission, and the field owner's animal eats them, he is exempt. If the animal is injured, then the grain owner would be liable. If the grain owner had permission to leave them there, the field owner would be liable for them being eaten. The Gemara says this is in accordance with the opinion that the owner needs to accept responsibility of the items placed in his field for him to be liable if they're damaged, and that's what occurred in this case. New Mishnah. If somebody sends fire with somebody mentally incompetent, his liability is not enforced by the court, but by God. If he sent it with somebody mentally competent, the mentally competent person would be liable. If somebody brought fire and then somebody else put wood on the fire, the wood guy is liable. If somebody placed placed down wood and somebody placed fire with the wood, the fire guy is liable. If somebody else fanned the fire, he would be liable. If the wind fanned it, everybody's exempt. The Gemara says the liability by God, if somebody hands a mentally incompetent person fire, applies if he handed him a coal that got fanned into a fire. If it was actually fire, this causes damage and he would be liable by the court. Others disagree as it was still the mentally incompetent person that did the damage. He'd only be liable if he gave the man thorns, pieces of wood, and a flame. The remaining points are qualified. It says if a person and wind fanned a flame at the same time, he's only exempt if the wind was sufficient to set the fire up by itself. This is not comparable to winnowing chaff by Shabbos, where there's liability even though the wind is helping him, as either here in this case he and the wind are fanning from opposite directions, or he was fanning with a normal wind that suddenly just got a lot stronger. It's that he was just blowing on the fire, or there's just a difference between Shabbos, where purposeful labor is forbidden, and this, where a causation has exemption. New Mishnah, if somebody sends fire and it travels and burns somebody's wood, stones, or earth, he's liable to repay based on a verse. The Gemara explains the necessity for all the specifications within the verse. Related, it says a concept that, similar to fire by grain and thorns, based on a verse, that tribulation enters the world due to the wicked, but it starts on the righteous. It expands on many different related verses from these topics. These are discussed further. New Mishnah, if a fire crossed a wall 4 cubits high, or a public road, or a river, the fire's owner is no longer liable. The Gemara additionally qualifies these as to the parameters of each of these particular barriers. New Mishnah, if somebody lights a fire on his property, there's debate as to how far the fire can spread. Some say it's viewed as if it's at the center of a 274 by 274 cubit square, which is a particular form of measurement. Some say it can go 16 cubits, the width of a typical public road. Some say 50 cubits, some say it just depends on the fire. The Gemara says this last opinion means it depends on the height of the fire, and it is the opinion we hold like. New Mishnah, if somebody sets grain on fire and utensils were inside and are destroyed, it's debated if he also needs to pay for the utensils. If there was a kid bound to the stack and a slave that was just nearby and somebody burnt the grain stack and the kid and the slave burnt, he's liable to pay for the kid and the grain, but he does not need to pay money for the slave, as the slave could have just walked away if he wanted to. If the slave was tied to the stack and the kid was just nearby and everything burns, the burner is exempt from payment, as he's getting the death penalty for murder instead. It's agreed that if somebody burns a large tower, he's liable to pay for everything inside, as people typically keep things in houses. The Gemara additionally qualifies these points. These principles are discussed along with a number of unresolved points. New Mishnah, if a spark came from a hammer and damages property, he'd be exempt. If a camel carrying flax in a public domain walked past a shop and the flax caught fire from a shopkeeper's lamp that was indoors and then burnt down a building, the camel owner is liable. If the lamp was outdoors, the shopkeeper is liable. Some say if it was a Hanukkah candle, the shopkeeper would not be liable. The Gemara debates based on this last opinion if it means that a Hanukkah candle must be within 10 handbreadths of the ground, because if it could have been higher, then he should have just placed it higher. But we say no, as they didn't want to inconvenience people to have to build a lamp above foot traffic level. Some add a Hanukkah candle placed 20 cubits above ground is invalid, similar to the laws of a sukkah and a mavoi crossbeam. And that's the end of chapter 6. Chapter 7 of Tractate Bava Kamma continues on the laws of property damages. The first Mishnah says, the requirement to repay something in double applies more than the requirement to pay something by an additional 4 or 5 times its value, as the requirement to pay double applies to things alive and not alive, while 4 times and 5 times payment applies specifically to oxen and sheep, depending on the animal, based on the verse. If somebody steals an animal after it was already stolen, or slaughters or sells a sheep or ox after it was stolen, he would only repay the base value of the item, not the double or 4 or 5 times excess. The Gemara says, another difference that some hold between double and 4 or 5 times payments is that double payments apply if a thief stole money and if a person falsely claims a deposit was stolen from them, while 4 or 5 times payments only apply by a thief. It additionally cites scriptural sources for the above points. It further expounds on the concept derived from these verses. There's a later case. If a man deposits an item with a person and this person informs him that he lost the item and he takes an oath that that occurred, and then witnesses testify that the borrower had just consumed the product himself, he pays just the base value of the item. If he admitted to this on his own without witnesses, he pays the base value and the fifth, plus he brings an asham offering. Further, if he had testified that the item was stolen and he takes an oath, but then witnesses come and say that he himself had stolen it, he would need to repay double. And if he admitted to it on his own without witnesses, he pays only an additional fifth, and he brings the offering. So this source essentially says that if somebody falsely claims their deposit was lost, they don't pay double. And if somebody falsely claims their deposit was stolen, they'd only pay double if they took an oath. It gives sources and debates over the interpretation of a few verses. These points on scriptural derivation are described at length and further argued on. It debates the particular necessity of various specific words and what concepts can be derived from them, and interprets this discussion in accordance with both opinions, which is described further. Anyways, there's a conversation as to the amount given when paying the value of an item. It said, if somebody is paying the principal base value of an item, he pays the value of the item at the time he stole it, and if somebody is repaying excess, double, or 4 or 5 times the value, it's paid in accordance with the value at the time of the trial. There are verses cited as source. It debates this further from various seemingly contradictory sources. Another source says, if monetary reimbursement is being paid precisely, it'd have the 5th addition, but if it's not paid precisely according to the principle, they would not add a 5th and would need to bring a guilt offering. It discusses verses which imply this point. It said that if an item changes during the period where it's stolen, it is technically acquired by the thief, which would mean he'd need to repay with money, not with the item. For instance, if he stole a calf and it grew up to become a bull, he'd need to give financial restitution as opposed to the actual animal. And if he slaughters it, it's technically his own animal at this point, so he would not need to pay excess here. Others strongly debate this principle. Others say that if there is an actual change in the animal, that would make him acquire it, but it's not sufficient that the animal just grew up. The animal would need to actually change its classification. Others say there is no change in classification, as even a young bull could sometimes be referred to as a bull. This is sourced from a broader debate on this topic between Beis Hillel and Beis Shammai. They essentially argue over if a physical change in an item that was stolen causes it to change ownership to the thief, although it is agreed that the excess payment goes according to the time that it was stolen. Others still debate this, and it brings various sources for this concept. Besides for the item changing, causing the thief to acquire it, it's also said that the owner giving up on the item causes the thief to acquire it, although it is debated if this is a biblical or a rabbinic concept, depending on if it's comparable at all to the laws of a lost item or not. If it was rabbinically instituted, it would have been to increase the likelihood of thieves repenting. However, it is said that this principle doesn't apply to any degree. Further, it said that if the thief causes a change to the item, changing the status and designation, he would acquire it and need to repay with monetary reimbursement, such as doing something like making wood into vessels, which creates a sufficient change that he acquires it and would now need to repay monetarily, not with the actual wood that he had stolen. There was that case, which has been cited a few times, which said that if a beam is installed into a house, the thief could return only the monetary reimbursement. And instead of citing this reason that we're explaining here, that he changed the status of an item, it said that the reason was instituted to encourage repentance. So some say this is different, as in spite of its installation, it is still called a beam. Others say it's different, as it could be removed and revert to its original status of a beam. The notion that if the item is removable, its status is not changed is said to be particularly here, and does not apply by the laws of using drawn water for a mikvah, for instance, where the laws are rabbinic and more lenient. On the notion that the original owner giving up hope of recovering the item, which could possibly create an acquisition by the thief, we suggest that it possibly could work, as there's a case where a thief forces people to consecrate their items or to give tithes, so that possibly is as they gave up hope of recovering the item, but it's actually suggested to be that there the item changed status, as explained. It cites verses from scripture to support these principles. It does conclude that the owner giving up hope does not cause the thief to acquire the item, although this was possibly retracted. Back to the notion that 4 times and 5 times payment applies specifically to oxen and sheep, it further debates the verses which source this and as to why it doesn't apply to other principles. It was also said that if somebody steals a stolen object, he wouldn't pay the excess double payment. Some said this would apply only if the first and second thief had stolen it without the original owner giving up on it, as if he had, the first thief would fully acquire it, and then the second thief would be fully stealing from him and need to pay double. Others do still disagree. They debate this from a number of different logics as to whether the theft must have occurred before or after the original owner gave up on the object. Specifically, if somebody does end up selling an item he stole prior to the actual owner giving up on it, it's a debate if the thief is then responsible to pay the excess 4 or 5 times payments. Some say there would be a liability, as the verse specifies the man selling the item and paying excess without reference to the owner giving up. Others say no, as since the sale wasn't effective, as the owner hadn't given up, he's not held responsible to pay excess. They argue from further explanations. This goes further, and there's a similar dispute if this excess liability applies if the item was sold after the owner gave up. Either he would be liable, as this opinion says excess is paid no matter if the owner gave up or not, or he would be exempt, as he'd hold the owner gave up, so he gains a degree of ownership and therefore doesn't need to pay excess. It debates this from a case where a thief stole an animal, then consecrated it, and then slaughtered it. He paid double, but no 4 or 5 times payment, which is seemingly after the owner gave up, but others interpret this case to be that the owner did not give up, and the owner, not the thief, was the one that consecrated the animal even though the thief had stolen it. This is in accordance with the opinion that such a consecration is permissible, as others do disagree. Additionally, the thief would need to pay the double payment here, as this was judged necessary before the consecration when it was still in his actual ownership. Then he would not need to pay the 4 or 5 times payments, as he then slaughtered the animal after the court told him to return it, thus making him have the status of a robber, one who acts brazenly as opposed to a thief who acts sneakily, and is somebody who needs to make 4 or 5 times payments. However, if the court had only told him that he's obligated to return it, not a direct ruling, and he slaughtered it, he'd still be classified as a thief and would make the 4 or 5 times payment. Anyways, in the original case, as mentioned, some say neither the thief or owner are even permitted to consecrate the animal, and that's debated from additional conversations. It's discussed further on if such consecration is permitted based on various laws of tithes. It argues as to who holds these opinions. It's stated based on the principle that such a consecration, when the owner gave up on the item, would not be allowed by either party, that a person is not allowed to write a document of authorization to have somebody else collect the debt for him. Others say this refers to the writing of a document of authorization for collecting movable property that the debtor denied owning. Further, they stated that such a document of authorization that does not have the words permitting the man to go and take legal action against the man, to take possession of the owed item and collect it for yourself, the document is not valid, as the agent here with the document does not have full authorization. If the man gave his collector authorization over half or a third of the item, it's sufficient, as he therefore can dictate policy on all of it, as he owns a portion of it. If the collector has full authorization and grabbed the item, the court lets him keep it due to his full authorization. Others say the owner and collectors are partners in ownership, and there's a practical difference if you can let the man take half the item, which a partner can, but an agent cannot. It's ruled that the collector here is legally deemed to be an agent. New Mishnah. If a man steals an animal as 2 witnesses testify, and they or a different pair of witnesses testify that he then slaughtered the animal, he must pay a 4 or 5 times payment. Such a payment would also be necessary if he sold the animal on Shabbos, Yom Kippur, or for idol worship. If the man stole his father's animal and then slaughtered it, and then the father passed, meaning he inherits from him, or if he stole an animal, slaughtered it, and then consecrated it, he would still need to pay the 4 or 5 times payments. Additionally, if he stole the animal and slaughtered it for medicinal reasons, or to feed his dogs, or the animal has a blemish that would cause it to die within 12 months, or he slaughtered a non-sacred animal in the temple courtyard, in all these instances, the 4 or 5 times payments would still be necessary. Others say he's exempt from this payment in the last 2 cases. The Gemara additionally quotes the author of these statements in accordance with their opinions. There is a discussion, broadly, if somebody is seen having possession of a field for 3 years, it creates a presumptive state of ownership by that individual towards the field. However, if 2 witnesses see him eating the produce from the first year, and then separate witnesses see him eating produce from the second year, and then separate witnesses see him eating produce in the third year, it's debated if they combine to create a state of presumption of ownership of the field. Some say it is sufficient, others say testimony must be on a complete matter, not on separate parts. It debates the sources from additional cases. We said if a man steals an animal and sells it on Shabbos, he must pay a 4 or 5 times payment. There would be an exemption for this excess payment if the thief was also liable for the death penalty through this sale. For instance, he exchanged the animal by moving it into a private domain. There's variation on this, some clarifying that it's specifically when the animal is transferred in ownership right when it hits the ground of the opposite domain to make the case work like their opinions. There is variation on this. The reason there's liability for excess payments after selling an item on Yom Kippur is because there is still a punishment of lashes, and this opinion holds that a punishment of lashes overrides monetary punishments. It debates this from seemingly contradictory related discussions regarding punishment for violations of Shabbos. It further debates these opinions. It poses a question if somebody stole an item belonging to 2 partners, slaughtered it, and then admitted his theft to one of the partners, exempting himself from the excess payment. It debates if he then need to pay excess payment to the other partner. It's essentially a debate largely based on verses whether the excess 4 or 5 times payment can be paid partially, or if it must be done in full. Based on the fact that we said if a thief slaughters a non-sacred animal in the temple courtyard, he would make excess payments, this is suggested to imply that the act of slaughtering is completed at the end of the slaughtering process. This is as if slaughtering took effect starting from the beginning, the animal would immediately be made prohibited and therefore ownerless. Others disagree and say that although the slaughtering process starts from the beginning, it's only considered to be completely slaughtered after it's finished, and in this case the animal started being slaughtered outside the temple and was then completed inside the temple. There's variation on this debate. New Mishnah. If 2 witnesses testify that somebody had stolen a sheep or an ox, and they also testify that he had slaughtered it, but then it's found out the witnesses were lying, they receive the punishment they try to give, and will have to make the payment plus the excess 4 or 5 times sum. If it was 2 separate pairs of false witnesses, the pair that testified he had stolen the item makes a double payment, and the pair that testified he slaughtered it makes either a double or triple payment to equal the 4 or 5 times payment. If it was only the second pair of witnesses that were lying, the thief makes a double payment, and the false witnesses make a double or triple payment, respectively. If only one of the second witnesses was lying, the entire latter testimony is null. If one of the witnesses from the first pair was lying, then the entire testimony of everybody is null, as there isn't sufficient testimony to prove that he had stolen the animal in the first place. The Gemara says, there's a dispute if a false witness is disqualified retroactively or from the point of disqualification. Some say it's retroactive, as the false witness is at that point established to be a wicked man, and this would take effect retroactively, while others say, as is a unique case, essentially, as the witness is proven false by the testimony of other witnesses, so there's no reason to believe these later witnesses over the initial ones, besides for the fact that that's just what's ruled scripturally, so it's not a point that could be then applied retroactively. Others suggest that there would not be retroactive nullification of the witness's testimony, as that could retroactively ruin any sales made with the items from the case in the interim. There would be a practical difference with these reasons for no retroactive testimony nullification if either 4 witnesses testified on the false witness, 2 on each, or that the 2 new witnesses testify that the original witnesses were actually robbers, which is why their testimony is invalid, where the first explanation would not apply. It debates which opinion we hold like, and the opinion that the witnesses are disqualified retroactively, like the opinion of the sage Abaya, could be one of the few times we actually hold like his opinion instead of the sage Rava. It debates this from other cases, but that's the opinion we do hold like. This is discussed relating to a number of further cases. It debates the status of 2 testimonies said on both stealing the animal and then slaughtering it, with a pause in between whether the second testimony is invalidated. It debates if this would affect the prior testimony, depending on the length of time between these 2 testimonies and whether it makes it considered to be a continuous testimony or 2 separate testimonies. It debates the length and status of this interim pause time frame. It said, if witnesses falsely testify on a case of capital punishment and then other witnesses dispute their testimony, and only then they're proven to be false witnesses, they would still receive capital punishment even though their testimony was invalidated, as the contradictions of the second witnesses are deemed to be the start of the process of proving them to be false witnesses. It debates to this point from other sources regarding laws of emancipation due to injury. This case is discussed further. It brings various other sources for these points. In the Mishnah, if 2 witnesses testify that a man stole an ox or a sheep, and then 1 witness, or the thief himself, testified that he had slaughtered the animal, he pays the double payment for stealing it and no 4 or 5 times excess for slaughtering it. If the man slaughtered and stole the animal on Shabbos, which is a capital offense, or on Yom Kippur, or slaughtered it towards an idol, or stole his father's animal and the father then passed, or he stole it, consecrated it, and then slaughtered it, the thief pays double and no 4 or 5 times excess. Some say if it's a sacrificial animal that the man is responsible for, and he slaughters it, he pays the 4 or 5 times payment. If he's not responsible for it, he does not. The Gemara says the initial point of comparing a single witness testifying that he slaughtered an animal and himself admitting it is to show that if he admits himself that he slaughtered the animal, and then a second witness showed up to corroborate his testimony, the same principle would apply as if he had joined with a single witness, and the thief would now be responsible to make the excess 4 or 5 times payments. Others do debate this point based on discussion of emancipation through injury and the number of witnesses required to view it. It argues on the interpretation of verses as sources, and additionally on the point that if somebody admits to his own guilt, he would not be liable to give excess payments due to future witnesses. This concept is discussed further. Now, this notion would apply if the thief admitted to the principal crime of theft, which requires payment of a sum. If he admitted to something that would require payment of excess, such as that he slaughtered the animal prior to the witness's testimony, it's debated if this would exempt him from any sum. It was stated, if somebody steals an animal, consecrated it, and then slaughtered it, he is not liable to pay the excess 4 or 5 times, as he's not slaughtering the owner's animal at this point after the consecration. It now belongs to the temple. However, he would not be liable to make the payment simply by consecrating it, as this holds in spite of his consecration, it's not considered to have legally switched ownership to a second party. Some suggest the difference is if the consecrated animal was an offering that the man maintains responsibility for, so the thief in this case would still maintain a degree of ownership and he would be exempt from excess payments. Otherwise, this would not apply. This point is qualified further. It discusses this regarding various types and steps of the offering process. For instance, some would, if the blood by the animal is ready to be sprinkled, it's as if it was done. This would also apply, for instance, if the animal was ready to be redeemed, it's as if it was actually redeemed at this point. This would be seen by the red heifer, which was ready to be eaten for a period, and is therefore susceptible to impurity afterwards. So it could be made permitted for consumption through redemption. It discusses the various opinions on this topic. A source says there would be liability of the 4 or 5 times payment for stealing a hybrid sheep and goat animal. This is based on some unique wording in a verse, and it explains similar wording by other concepts. It discusses these further, and there are additional points. New Mishnah. If a thief steals an animal and sells it, but retains a small portion for himself, a hundredth, for instance, or if the case was that he stole an animal he partially owned, or he stole somebody's animal and slaughtered it, but did so improperly so it became non-kosher, or he didn't even slaughter it, he just killed it, or did other forms of improper slaughter, by all these cases the thief pays in excess of double, but not the 4 or 5 times payment. The Gemara says when he sold it, but retained a small portion for himself, some say it's a portion that needs to be slaughtered, others say it's the fleece that he's keeping. A different source seems to disagree with the first opinion, saying he's exempt if he retains the horn, which does not need to be slaughtered. So it must be that he holds like a different quoted contradictory source, which does line up with his opinion. Similarly, there are contradictory quotes on the point of stealing an animal during a partial ownership. Some say there's liability to pay the excess 4 or 5 times payments. Others disagree. It's explained that the difference in quoted cases is that actually both are where a thief and his partner steal somebody else's animal, and he's only liable if he then slaughtered it with the other partner's knowledge and consent, as the act has to be accomplished fully in partnership. There are several potential cases which are then posed. What if the thief reserved the rights to use the animal for 30 days before the sale? What if he stipulated in the sale that he gets to keep the animal's labor? What if he sold a pregnant animal and kept the fetus, which is qualified? And all of these go unresolved. Additionally, it's stated that if somebody steals an animal and then has somebody else slaughter or steal it, he's essentially just made the man his agent, so the thief will be responsible to pay the 4 or 5 times sum. There are other principles discussed. New Mishnah. If somebody stole an animal, but still while it's in its owner's domain, and then slaughtered or sold it outside, or vice versa, or he did both outside, he'd be liable to make the excess 4 or 5 times payment. Specifically, if he stole and then slaughtered or sold the animal, all while still inside its owner's domain, he would not be liable to pay this excess. If the thief was just leading the animal outside its owner's domain and the animal died, the thief is not liable to make any payments. If he was physically carrying it out and it died, he would be liable to pay reimbursement. If the thief told somebody else that they could take somebody else's animal as payments, such as for the redemption of a firstborn, to repay a debt, to give to an unpaid guardian, a borrower, a paid guardian, or a renter, the same laws apply. The thief is exempt if the animal dies as they're leading it out, and liable if it dies as they carry it out. The Gemara debates this principle of physical acquisition, treating responsibility essentially. Does it apply to somebody who agrees to guard an animal? Does he need to similarly physically acquire it to be responsible? Based on the Mishnah specifying a guardian must do this act of acquisition to make a thief responsible for theft, this would create the principle generally to cause responsibility for an animal. It quotes another case, if a man is seen hiding, meaning he's a thief, so he could be liable for 4 or 5 times excess payments, and he slaughters an animal, he would be liable, specifically if he struck it with a stick, for instance, causing it to move, and therefore causing this described acquisition liability. It discusses the difference between a thief and a robber, and it quotes many verses on the subject and on the negativity of being either one of these. It also quotes points on why the ox has the 5 times payment and the sheep specifically has 4 times payment, such as the ox ceases labor due to its theft, and also the sheep is less and it has to be physically carried if it's stolen. New Mishnah. Due to issues of animals grazing on crops, it was forbidden to raise smaller animals, sheep, and goats in Israel, but it was permitted in Syria and the wilderness around Israel. Additionally, raising chickens in Jerusalem was impermissible due to concerns of them dragging impure items and contaminating sacrificial meats, and similarly, Kohanim couldn't raise chickens anywhere in Israel. Additionally, raising pigs anywhere was forbidden, raising dogs was allowed so long as they were chained, and also spreading pigeon traps was only allowed if it was 8,000 cubits from a settled area. The Gemara further qualifies particular permitted regions for raising animals. There are details, such as it was allowed to keep animals 30 days before a pilgrimage holiday or 30 days before a son's wedding, and similar. Some say it is allowed to keep these animals so long as it's just not on the fields and they're just kept indoors. Additionally, it's stated that if somebody did impermissibly have these animals, he's not required to sell them all at once. He can just do it over a period. Similarly, if somebody vowed to purchase a house or marry a woman in Israel, he can do this at whatever pace he wants. It cites incidents related to this. It also says an opinion that a person can have animals that clear vermin, such as village dogs, cats, monkeys, and other animals, which it defines. Some said these particular laws of Israel also applied in Babylonia. It cites incidents on this, and it debates whether a white cat is more dangerous than a black cat. There are a number of unrelated points. It says that the alarm would ring out even on Shabbos due to a particular plague of boils. It said that a door that's locked will not be opened quickly, which is possibly a metaphor for difficulty in being ordained rabbinically, among other suggested opinions. And if somebody purchases a house in Israel, they can have a non-Jewish individual write the bill of sale on a Shabbos. Further, it's taught that Yeshua made a number of stipulations towards all the tribes living within Israel. Their animals could graze in forests, they could gather wood from each other's fields, they could take from springs, they could fish in the Sea of Galilee, an unburied corpse is buried where it's found, and many, many others, which are then explained and defined further. These are all discussed at length. It lists a number of other instituted stipulations, now from Ezra the scribe, that the Torah is additionally read from on Shabbos afternoons and on Mondays and Thursdays. Courts convene on Mondays and Thursdays. Women should comb their hair before immersing in a mikveh. Immersion should be done by men after having an emission, and many others. Again, these are additionally explained. It brings a number of other specific laws that applied solely in Jerusalem. Houses there could be bought back a year after sale. The city could never become designated as an idolatrous city. Placing garbage dumps there was impermissible. Raising chickens was forbidden. Leaving dead bodies overnight was forbidden there, and many others. Again, these are all explained further along with quoted sources. As I mentioned earlier, raising pigs in Jerusalem was forbidden due to the war between Hyrcanus and Aristobulus. Men would bribe soldiers around the siege to give them animals so that way they could keep doing the temple offerings in the temple. But once the soldiers outside swapped the animal they were giving for a pig, and when they were carrying it up, it stuck its hoof in the wall, and then the whole city shook. So pigs and also Greek wisdom were henceforth banned. Rabban Gamliel's family was the exception, being allowed to learn Greek wisdom as they were close with the government. There are further points on the issues with raising dogs and the maximum range that pigeons fly in regards to setting traps around cities. And that's the end of chapter 7. Chapter 8 of Tractate Bava Kamma continues discussing laws of damages. The first Mishnah says there are 5 particular types of payment given if a person injures another person. Payment for damage, pain, healing, loss of income, and humiliation. Damage is assessed by judging how much the injured man would have been worth if sold as a slave before and after the injury. Pain is assessed by how much a person would be willing to pay to not suffer the particular pain. Healing cost, medical bills effectively, is assessed from the caused injury and any wounds resulting from it, but no further. Loss of livelihood is not actually assessed based on what job the injured man actually works, as he already received payment for the damage to his hand or leg, which took that into account regarding his value assessment. Instead, it goes according to the wages of a set job, here of a cucumber watchman. Humiliation is dependent on both parties. The Gemara says the source for this is the verse that discusses repayment, with an eye for an eye or a tooth for a tooth upon injury, which obviously isn't literally a responsive counter-injury, based on the fact that the verse also compares it to injuring an animal. A person who is injured is repaid monetarily, similar to an animal, and not literally injuring the other person as recompense. It quotes other verses as sources. It further describes at length as to how each listed form of monetary liability are referenced throughout the verses. Additionally, there is one disagreeing opinion that says that the monetary value of damage is actually assessed from the damager. It cites some cases on these principles. A donkey injured a child once, severing the boy's hand, so they wanted to calculate the damage value by assessing his worth as if he was a slave, but the father refused this, saying it was demeaning, offering to pay the sum himself when he got older. Others say this calculation is not necessary in courts in Babylonia, but it is done in case the damaged party seizes property from the damager, so we can know how much they should keep. The reason for this difference between judges in Babylonia and in Israel is that judges in Babylonia were not deemed to be properly ordained, so all cases can be judged in Israel, while in Babylonia they would only judge cases that involved common matters and a monetary loss. It qualifies what cases exactly are included in these categories. Regarding payment for pain, this would apply based on verses even if there was no physical damage. Regarding the calculation of a pain assessment, it argues as to how this would be calculated if it involves a significant injury, such as somebody's hand being severed. It's explained to be calculated by if somebody was decreed against by the government to lose his hand, and it was going to be by the sword, which would be very painful, how much would that man be willing to pay to have it removed instead through a drug, meaning painlessly. Regarding the other payments, if the injury grows and reopens, if it was all due to the original injury, the injurer must pay additionally for this with medical costs and work loss. Some say he's only liable to pay the medical costs, others say medical costs and the work loss are just always paired together. This point is discussed further and it quotes additional sources. Additionally, if the injurer offers to heal the injured party himself or to arrange a free or distant doctor for him, the injured party can refuse this as he doesn't prefer these doctors and receive the monetary payment. Similarly, the injurer can refuse to give a set amount of money without it being assessed towards a specific doctor in case it's being overvalued. It further brings verse sources for these principles. Additionally, there are cases where these injuries of a person payments can be made individually. A pain payment can be made alone. If the injury was on his nail, for instance, For medical payments, if somebody gives him a drug that discolored his skin, there could be payment only for loss of livelihood if the man was just locked in a room, and there could be payment only for humiliation if he was spat on, for instance. It further calculates a payment for loss of income, which, as said, was based on the income of a cucumber watchman. Others say there's variation on the job based on the injury. There is a theoretical case when if a man injured somebody, severing his hand, and then, before the loss of income sum is calculated, he also breaks his leg, blinds him, and deafens him, and asks, does it calculate the loss of work by each individual injury, or all at once, at the end, which has variation if he's going to be paying extra for repeated instances of pain and humiliation. It's left unresolved. It also asks, what if somebody injures another, but temporarily, that he'll be fully healed soon? Does this constitute necessity to pay for a reduction in his value, even if it's only temporary? It argues this from related cases regarding a person who injures his parents, and it said, it's a debate. Some say he receives payment for a reduction in value and for lost workdays. Others say he only receives payment for the lost workdays. Related, if somebody injures somebody else's slave, severing his hand, for instance, some say the payment for loss of value goes to the slave, and the loss of work goes to the owner. Others say both go to the slave, who uses it to buy land, which the owner can then benefit from. If it was an injury that does not reduce the slave's ability to work, a cut to the ear, for instance, in that case, all payment would go to the slave. It debates sources regarding payment for humiliation as to how it's assessed depending on the greatness of both parties. Additionally, a minor can experience humiliation and would be repaid accordingly if injured. New Mishnah, there is liability of payment for humiliation of a naked, blind, or sleeping person. If a sleeping man somehow humiliates somebody, he's exempt. If somebody falls off of a roof and injures a person, he's liable for the damages payment, but not for the humiliation payment, as this is only paid if it's intentional. The Gemara says if somebody is naked or in a bathhouse, there is liability for humiliation, albeit lower than normal, as he's already in a somewhat embarrassing situation. Some define this case of humiliation while naked to actually be where the wind blew at somebody's clothes, lifting them up, and then somebody else came by and lifted them higher to humiliate them. Similarly, by the bathhouse, they would define this as being by a river, where there's a bit more discretion. There's a question, what if somebody embarrassed a sleeping man, and then the sleeping man passed away before he woke up? This would be dependent on whether the humiliation payment is based on embarrassment or disgrace, or possibly, according to others, between his own embarrassment and his family's humiliation. Based on related cases, by mentally incompetent individuals, as said, is payment for the family's humiliation, which means a deaf mute would be paid for embarrassment, an insane person would not, and a minor would, so long as he's old enough to feel humiliation. It's actually a debate if blind people are subject to be paid for humiliation. This is argued. Based on verses, some do exempt blind people from just all civil law in the Torah. Others disagree. New Mishnah, if a person causes injury, this is more stringent than an animal causing injury, as he pays for damage, pain, medical expenses, loss of income, and humiliation. Also, if he caused a woman to miscarry, he also pays for the miscarriage. An animal damager only pays for the first damage, and it does not pay for miscarriages. Somebody who hits his father or mother, but not enough to cause a bruise, or injured somebody on Yom Kippur, this does not result in capital punishment, so they would be liable to pay the 5 types of monetary compensation. If somebody injured a Hebrew slave, he must pay the 5 types of compensation besides for loss of income. If somebody injured another man's Canaanite slave, he also must pay all 5 types of compensation, although some say not for humiliation. There is liability for injuring a deaf mute, insane person, or minor, but no liability for being injured by them. If somebody injures a slave or a married woman, they're liable to pay them. If the slave or married woman injures somebody, they're only liable once they are emancipated or divorced. If somebody injures his father or mother enough to cause an actual bruise, or if somebody injured a person on Shabbos, they would receive the death penalty, so there would be no monetary liability. There is no liability of payment if a man injures his own Canaanite slave. The Gemara debates, if somebody injured a man's minor daughter, who the payment goes to, possibly to the father, as he is her responsibility. It's debated. There's a number of suggested variations. If the daughter is reliant on her father, some say it goes to the father, some say it goes to the daughter, some say there's a variation if the injury in question would lower her eventual betrothal sum. It debates the logic from verses as to whether a man who injures somebody's Canaanite slave is responsible to additionally pay for humiliation. This is discussed along with additional points. It brings cases related to the above discussions, along with debate on whether a father holds rights to property sold by his son. It's discussed further. Related, financial advantage from the marriage contract goes only to the wife, with no benefit towards the husband, in accordance with one particular opinion. This is relevant regarding a debate. As we said, a married woman does not pay any owed compensations until she divorces, and she doesn't really independently own anything, so it debates a number of suggested items of things she can independently own. This point is argued further. There are additional principles on laws of emancipation discussed. New Mishnah, if somebody strikes another, he owes him a selah coin. Others say it's 100 dinarim if he strikes him, 200 if it's on the face, and 400 if it's with the back of his hand. It's also said to be 400 if he pulled his ear, pulled out his hair, spat on him, pulled off his cloak, or uncovered the hair of a woman in public. These compensations for humiliation are dependent on the status of both parties. However, some say that all Jewish people, as they're descended from the forefathers of Avraham, Yitzchak, and Yaakov, all maintain the legal status of a prominent individual. It brings a case if a man uncovered a woman's hair publicly and it was deemed necessary for him to repay her 400 dinarim, and in the meanwhile the woman was seen applying oil to her hair in public by removing her own hair covering. So apparently it wasn't that embarrassing for her, but nevertheless the man was required to pay her in full, as a person can make a decision to do something which is negative towards themselves, but somebody else can't do that to them. The Gemara debates whether the coins referred to in this Mishnah, if they're standard state coins or specifically of Tyrian currency. Based on a related case, it proves it's the latter. It discusses related points on the testimony of witnesses by these laws. Further, it goes through additional principles of damage evaluation. In regards to being spat on, some qualify this, saying it only applies if it lands on him, not his clothes, which would be similar to being embarrassed through words, where there is no liability of payment. Additionally, the initial statement, which said humiliation repayment is status dependent, meaning that as a leniency based on the fact that the following opinion qualified this to raise it to a stringency, saying all are considered prominent if descended from the forefathers. Regarding the above case with the woman having her hair uncovered and the oil, it was permitted to have a delay by payment, specifically for humiliation. This is qualified and related. It discusses many points on the prohibitions against a person injuring themselves or otherwise causing themselves or their property damage. This is discussed. New Mishnah. In spite of the fact that an injurer pays reimbursement to the man he injured, he's only forgiven in heaven once he receives the man's forgiveness. If the injured man refuses to forgive him, he's deemed to be cruel. If somebody requested a person to injure him, even offering him exemption from payment, if the man injures him, he's nevertheless still liable to pay him. If he requested that he break his property, if somebody does so, they're still liable to pay, unless he offered him an exemption wherein he'd be exempt. If somebody offered a man exemption from payment to damage somebody else, the damager is still fully liable, whether he damaged the other man or his property. The Gemara qualifies the fact that heaven doesn't forgive the man until he gets forgiveness is for the pain he causes. It discusses related verses. Related, it said that if somebody prays on behalf of another and he also needs assistance with that thing, he will be answered first. There are further verses quoted on this principle. It quotes a bunch of additional general teachings about proper behavior and conduct along with the verses. There are more of these. Regarding a person who requests another to injure him, some say this maintainment of liability is only if it's the severing of an extremity, where the man wouldn't really mean it. Additionally, the responsibility towards breaking an item, even if told otherwise, according to some, is only where he was first given it to take care of. It brings related cases. And that's the end of chapter 8. Chapter 9 of Tractate Bava Kamma continues in the laws of damages along with the principles of theft and robbery. The first Mishnah says, if a person steals wood or wool and then crafts it into a vessel or a garment, he repays the value of the original item that he stole, not the more expensive item he turned it into. Similarly, if a person stole a pregnant cow and it then gives birth, or a sheep which he then shears, he must repay the value of the cow while it was pregnant and of the sheep while it was unshorn. Or, if a person stole a cow or a shorn sheep and it becomes pregnant or grows wool while he has it, he repays what its value was at the time that he stole it, which is a general principle. The Gemara says, the thief has changed and acquired the wood or wool when he makes it into a vessel or garment, and only pays the original value. However, if he only sanded the wood or washed the wool, it's a debate if this is a sufficient change to form an acquisition between a few sources. There's variation. Some say there is a difference whether it's a reversible or irreversible case, which would affect whether it's considered to be a legal change biblically or rabbinically. Others say the difference between cases is whether it was a significant change, whether the wool was untangled or combed, or possibly if it was whitened or bleached. Others say there's variation if it was washed with dye on the type of dye, as some are permanent, others are not. Some hold simply if an item changes, it still nevertheless retains its prior status. This is debated from a number of sources, and it discusses various principles of charity ties. It's held like the opinion that if an animal degrades in value and deteriorates after stolen, it's returned to its owner in its current state. Some clarify this only applies if the deterioration is reversible. There are related points, and it mentions it was discouraged to accept an item that was stolen from you if the thief tries to return it, so as to more encourage repentance in thieves. This concept is additionally discussed. Regarding stealing a pregnant cow or sheep where it gives birth or is shorn, we said it's repaid according to its value at the time it was stolen. Some, however, said to return the animal and its offspring or wool, and it debates why. Possibly he holds if it changes, it still retains its status, or possibly he doesn't hold that, but says it must be returned as an additional penalty. There's a practical difference if an animal went down in value since it was stolen. It debates this from a few cases, and it proves that it is due to a penalty. This is additionally discussed. There are other opinions on this topic. Some say that the animal would be returned as is, others say it's as if its value was assessed at the time of robbery. There's difference if the addition to the animal is still there, if that's also returned between these opinions. Others say they agree, it stays with the thief, and their debate is if the owner can get a percentage of the value of the addition. And further debates these opinions. Related, if a man steals an item, enhances it, increasing its value, and then sells it, the original owner must pay for the enhancement in the item. The same applies if the purchaser himself enhanced the item. If a non-Jewish man had stolen the item, enhanced it, and sold it to a Jewish man, this leniency would not apply, and he would not get to retain the enhancement when he returns it. If a Jewish man stole it, sold it to a non-Jewish man who enhanced it, who then sold it to a Jewish man, it's unresolved what the status is. It's been established that changing an item creates an acquisition by a thief. If he cut down somebody's tree to steal it, or even made them into logs, this is not considered to be a sufficient change to form an acquisition. Logs being turned into beams is sufficient. Large beams being turned into small beams is not. If they were turned into boards, this is a sufficient change to form an acquisition. Stripping a palm tree from its leaves is sufficient of a change. It clarifies more of these. It debates if splitting the central twin leaf of a palm frond, if this is considered to be a sufficient change to create acquisition. Turning earth into a brick is not a valid change, as it could be turned back into earth. Turning a brick into earth is sufficient, as even if it is changed back into a brick, it's considered to be a different brick. The same applies with melting silver into coins and vice versa. It gives more examples. The general established principle that a stolen object is returned according to its worth at the time that it was stolen includes if a calf or a lamb were stolen, and then it grows up into a cow or a ram. That's a valid change, creating an acquisition, meaning the thief can slaughter or sell the animal without suffering any excess liabilities. It gives instances of cases. New Mishnah, if somebody stole an animal or a Canaanite slave and they aged over time and decreased in value, he must return their value at the time he had stolen them. Others say this does not apply to a Canaanite slave, he just returns them as is. Payment goes according to the time of theft if the item reduced in value, be with a coin that broke, vegetables that rotted, wine that went bad, and similar. Exceptions to this, where the item is just returned as is, even if it had decreased in value, are coins that were made invalid by the government, teruma that became impure, leavened bread where Passover passed by, or an animal that was made impermissible through sin because it killed somebody and was going to be executed or otherwise. The Gemara says, when it says the animal aged and is repaid according to its original value, it means any form of deterioration, not just aging. It's held that Canaanite slaves are returned as they are. These opinions are discussed further. It brings additional opinions on these laws. It mentions if somebody has another person's slave work for him for a bit, he does not need to pay the owner, as this benefits both of them, as it also has the slave practice. Others clarify that this should still not be done if the owner of the slave owes money to the other man, as otherwise it'll just look like he's charging interest, which is not allowed. If somebody uses another man's ship without permission, some say he must pay either the amount he should have rented it for, or the diminished value of the ship. Others say he must pay the diminished value of the ship. Some say the difference in opinions is the first is when the ship is available for renting, the second is where it's not. Others say they agree it's available for renting. The first opinion says it's where he took it intending to rent, the second is where he intended to steal it. When it said a coin broke and decreased in value, some say this means literally, others say it refers to the government canceling the currency. If the government invalidates it, it's not considered changed if it's still allowed in other regions. Those that say a coin is cancelled by the government is not considered to be changed. This is unlike rotted produce and similar, as the coin itself is not changing. If somebody borrows a specific type of coin, which the government then removes from circulation, some say he must repay it with a valid type of coin in circulation. Others say he gives back the original coin to spend in a different country if he wants, so long as he has the means to get there. It brings additional cases on currency and consecration of coins. It also mentions several old currencies. One had the names of King David and Solomon on one side, and a picture of Jerusalem on the other. Abraham himself had a currency with an old man and an old woman on one side, and a young man and a young woman on the other. If somebody lends a person a coin on condition that he returns the same currency, and the government in the meanwhile increases the size of the coin, even by a large degree, he just repays with a coin that was in circulation at the time of the payment. It's also adjusted according to market value. Further, if somebody rolled somebody's coin into a sea, he's exempt if it's clear water and the man can just go get it back. This is only if he rolled it in. Picking it up and throwing it in is considered to be theft. If somebody flattens another man's coin, he's exempt as he hasn't reduced its value. If he files it down, he must repay him. This is debated. If somebody cuts a cow's ear, some say he's exempt, as it's otherwise fine, and although it's a blemish, most animals aren't brought as temple offerings anyways. Others seemingly disagree. There's also exemption for burning another man's promissory note, a receipt that can be redeemed for money, so long as there are witnesses who can draw up a new note. Others say if the man is trusted to request his money without the document, it's fine even without the witnesses. There are various opinions as to the validity of this point. The remaining points in the Mishnah are qualified. New Mishnah. If somebody gives an item to a craftsman to repair, a chest, box, cabinet, or otherwise, and the craftsman breaks it, he's liable to repay him. If somebody paid a man to demolish his wall and the man broke the actual stones, he's liable to pay him. If a man is knocking down a wall and the wall collapsed from a different side and damages something, he's exempt. If it fell directly due to his work, he's liable for anything that breaks. The Gemara says, a craftsman must only repay what he broke if he received a full item. If he was told to build something, a chest, that he then built himself and then broke it himself, he's exempt. It discusses this from various similar cases. Related, if an expert butcher slaughters somebody's animal and it winds up non-kosher as he did it improperly, he's liable to pay due to negligence, which means he'd pay even if he did this job for free. Others disagree that he'd be considered to be negligent, and it's debated between several opinions. If somebody brings money to a money changer and the money changer mistakenly says the currency is valid, causing the man to then lose money, one source says he's only exempt if he was an expert, others say he's liable no matter what. It's explained the opinion that says experts are exempt refers to where the coin was from a new press, so they just didn't recognize it. It brings instances of these cases. It's proven that some hold there's liability for damage caused through indirect action. New Mishnah, if somebody gives wool to a dyer, and the dyer burns the wool, ruining it, he needs to pay him back for the wool. If the dyer dyed the wool poorly, if the value of the dyed wool is greater than what the dyer spent, the owner repays that to the dyer. If what the dyer spent is greater than the additional value to the wool, the owner pays that to the dyer. If the dyer dyed the wool the wrong color, red instead of black, or vice versa, some say he repays the value of the wool, others say he pays either the increased value or repayment for the cost of the dyeing, depending on which costs more, as described. The Gemara defines what it means to dye something poorly. If a man gives a craftsman wood to make a chair, and the man makes a bench, some hold he is repaid for the wood, meaning the craftsman gets to keep the bench, others say he must pay the man the excess of what he spent or the increased value, whichever is less, meaning he does not acquire the bench. If the buyer requested a beautiful chair and he received an ugly one, it's agreed that the craftsman does not acquire the chair and the buyer must repay for the excess labor or value. It debates what the status is in the described debated dye case as to whether dyeing wool is considered substantive enough to create an acquisition by the dyer. This is debated from various sources and further argued on. It brings points on produce during the sabbatical year and it debates as to who we hold like regarding repayments for messing up dyeing wool. There are later opinions that seem to rule on this in later tractates of Bava Kamma and Bava Basra, so some say that they were written out of order, others say that these three tractates are just considered to be one big tractate. So it does seem to imply like the ruling that if the dyer messed up, he'd be repaid excess labor or increased value. Related, if somebody sent his agent to buy wheat and the man bought barley, some hold any loss or profit goes to the agent, others say loss goes to the agent and profit would be split. The difference in opinions is whether him changing the purchase formed an acquisition. Others disagree and say the dispute is whether the agent was sent to buy the wheat for food or for merchandise. This is further qualified. Further, it said if a man purchased a field in another man's name, the man does not need to sell it. If the man purchased a field in another's name, on condition that the man will sell it back to him, the man must sell it to him. It's debated as to what this means exactly. Some say it's that if a man tells somebody he's buying property on behalf of some great individual, so that way the sale won't be contested, even though he actually wasn't told to do so, the great individual does not need to give the property to the buyer unless that was the condition of the sale. Others redefine this case saying if a man is purchasing a field on behalf of his friend, the seller does not need to grant him ownership immediately unless that was the condition of the sale. This is discussed further along with related incidents. New Mishnah, if somebody stole from another a minimum of a value of a peruta coin and took a false oath that he hadn't done so, and he wants to repent later, he must return the money he stole to the original owner alone, nobody else besides for an agent of the court. If the man had died, he can return it to his heirs. He does not need to pursue the man to return the money if he's only returning the principal and not the excess fifth, or if the principal was forgiven but not the fifth, or if everything was forgiven save for a value less than a pruta. He would still need to pursue the man if he's only giving the extra fifth and no principal, if only the excess fifth was forgiven and not the principal, or if everything was forgiven besides for a remainder greater than a pruta. If somebody takes a false oath that he had already paid an excess fifth payment and then needs to pay an additional second excess fifth from the first, if he lies about that also, he needs to keep adding fifth payments until it shrinks to the value of less than a pruta coin. Broadly, if somebody steals after offering a pledge, a deposit, if he robbed, exploits somebody, swore falsely about a false item he found or similar, he needs to pay the sum of what he stole, the principal plus a fifth of its value, and he also needs to bring the guilt offering. The Gemara says, the implication from this is that if somebody did not take a false oath after stealing from somebody, they would not need to go excessively out of their way to return the item in accordance with one opinion. It debates between these opinions further. It's also said that the money must be returned directly to the man alone. If an agent was appointed before witnesses to collect a debt, it's debated if this is a valid agent. Some say yes, as he's been appointed as such. Others say no, as he's been trusted to deliver the money back only. It debates these opinions from sources. Based on the fact that we said if the thief returns a principal, but no extra fifth, he does not need to pursue the man to return the money. This would imply that the fifth is considered to be monetary restitution, not a fine, and if the thief dies, his heirs would need to pay it back instead. It discusses this and it cites several other sources. It brings up, what if the heir had taken the false oath regarding stolen items, and it brings variation depending on the accessibility of these stolen items and the means of repayment. Regarding the point that if both the principal and the excess have been forgiven, if there's less than a prota owed, he does not need to return it. That's only if it's not physically there, as if it is, it might go up in value. Others say this is not a concern. Related, if somebody steals 3 bundles of produce worth 3 protes, and their value drops to 2 protes, it said that if the thief returns 2 of them, he must still return the 3rd. He also said, as mentioned, if a person steals bread and passive repasses, making the bread prohibited for benefit, he can still just return it as it is. The logic of both is that the bread is returned as it still does exist and was originally worth money, and the produce too was originally worth a full prota and was returned accordingly. Related, it's asked, if somebody stole 2 bundles of produce, which together were worth a prota, and he then returns 1, does he need to return the other, as it is worth less than a prota? It said no, and there's also no mitzvah in returning the first half, as that also wasn't worth more than a prota. There are related cases on cutting the hair of a nazir, on sealing broken barrels, and similar. It brings lengthy discussion on principles of false oaths relating to theft and similar. Particularly, some hold that taking an oath in such a case on an item can create acquisition, and it's debated as to what exactly this refers to. Some say that a guardian of an object would no longer need to pay monetary restitution in such a situation. For instance, if a person claims that he left money as a deposit by a particular person, and that person denies it and takes an oath that it's not true, and then witnesses prove that the first man is lying, he would nevertheless be exempt from any payment, as the other man took an oath, creating acquisition, meaning there's no monetary restitution. There's a later case that's pretty similar, and the man took an oath, however, he actually would be responsible to pay monetary restitution there, as is explained. Either that oath was taken outside of court, so it doesn't count to this degree, or it's that he took an oath before the court required him to do so. These points are discussed further. Additionally, it said if somebody has an animal left with him as a deposit, and he claims somebody stole it, but in actuality he himself had, he would be liable to pay double, and if he had slaughtered or sold it, it would be the excess 4 or 5 times payment, just as it would be by a thief based on a juxtaposition of verses. These verses are debated on. Additionally, it said if a person finds a lost object and then steals it, and then claims some thief stole it, he must pay double. Also, based on a verse which is discussed, it said if somebody falsely claims that a thief stole his deposit, he's only liable to take an oath if he denies part of the claim of the debt and admits to part of it. This is explained as the normal reason he'd be believed without an oath is because his claim would be so insolent, essentially, that he's just automatically believed. But if he's admitting that he still owes partially, it's not that insolent, and he needs to prove his honesty with an oath. This would not apply by a loan where the man did him a favor, only by a deposit where he did not. Some say the 4 types of legal monetary guardians need to take oaths if they admit to part of their debt, being an unpaid watchman, a borrower, a paid watchman, and a renter. It brings sources. Some say if a man claims a thief stole his deposit when it was actually himself, he'd only be liable to pay double if he actually used it for himself. Others debate this point. There was an earlier source which said if a guardian falsely takes an oath that a thief had stolen his deposit and witnesses testify otherwise, he needed to pay double, but not an additional fifth for the false oath. It debates why. Some suggest that the monetary obligation for the double payment removes the need for the fifth payment. Others say that the fact that he took the oath resulted in him needing to pay the double payment and not the fifth. Based on a different source, it conclusively proves that it's the monetary obligation of the double payment that removes it. In the event that a person lent his ox to be washed by 2 people, and they both falsely claim and take oaths that the ox was stolen, and then the first one admits his guilt, and the second one has witnesses testify that he lied. So technically one should be paying a fifth and the other should be paying double, but perhaps it's considered just to be one monetary obligation, so both are not paid. It's left unresolved. So there's another case. If a man took an oath that an item he was watching was lost, and then admitted that he still had it, and then took the oath again, and then admitted he still had it, or something similar, so he's now technically liable for 2 extra fifth payments. It debates if both are paid and proves from a source that they are. Another case, if a guardian took an oath that the money in his deposit had been stolen, but decided to pay it back from his own funds anyways, and then the actual thief was caught, it's a debate who the thief pays the double payment to, the owner or the guardian, depending on if the guardian took acquisition of this payment when he reimbursed it by himself. This debate is based on various described sources. Related, there's a case if a guardian took an oath that a thief had stolen the deposit and the thief is caught, and the thief admits to the guardian that he stole the money, but then denies it to the owner, so the owner brings witnesses that it was stolen. It debates if the thief becomes exempt from double payment by admitting his guilt to the guardian. It asks further questions on this, which go unresolved as to further cases. If a thief stole a deposit from an unpaid watchman who's not responsible for such an occurrence, he can either try to get reimbursed by the thief or just take an oath that he wasn't responsible and be totally exempt. If it was a paid watchman, He can't just take an oath as he was responsible for it, so he must get reimbursements from the thief. Others hold even an unpaid watchman can't just take an oath to be exempt. The logic of this debated, but it stands unresolved. New Mishnah. If a guardian claimed an item in his deposit was lost and accepted an oath that that's the case, and witnesses then claim that he took it for himself, he must repay the principal. If he admitted himself that he had stolen it, he repays the principal plus a fifth and brings a guilt offering. If a guardian claimed an item in his deposit was stolen and accepted an oath, and witnesses claim he took it for himself, he must pay double. If he admits he took it himself, he pays the principal plus a fifth and a guilt offering. If somebody robbed their father, took an oath that it wasn't them, and then the father passes away, and he then admits his guilt, he pays the principal and the fifth to the father's heirs, his brothers usually, and brings a guilt offering, then he doesn't keep his own share of the inheritance. If he does not have enough to repay what he has stolen from his share, he borrows money and repays his creditors from his share. Related, if a father vows against his son benefiting from him and then dies, the son still inherits, as it's no longer the father's property. If the father vowed against his son benefiting from him during his life and during his death, he can't inherit from him and he gives his portions to the other heirs. If he's lacking in funds, he can borrow money and repay his creditors from his share. The Gemara says, if a son robbed his father and now needs to repay the heirs, as mentioned, some add, he can put the money in a charity purse if he wants, and some say he must clarify that it's what he had robbed. It's additionally debated if the son robbed his father, as he's inheriting a portion himself, why he can't just repay what he took from his own inheritance. It's explained in accordance with other opinions who reject the permissibility to forgive your own monetary obligations. It debates to this point from a number of other sources regarding robbery of converts and the laws of monetary restitution if they pass without heirs, which goes to Kohanim typically, as will be discussed. These principles go further. New Mishnah. If somebody robs a convert and takes a false oath that he hadn't and the convert passes, the thief must give the principal and a fifth to Kohanim plus a guilt offering, which is based on this verse. If the thief is going to deliver all this and then dies, the money is given to his own heirs and the guilt offering animal is left to develop a blemish and then sold as funds for the communal gift offering. If the money was given to the Kohanim before the man died and before the animal was offered, it stays with them. He must have the funds delivered to the Kohanim prior to the offering, and if the offering was sacrificed before he brought the funds, he must bring a new offering. It's fine if he had given the principal before the offering and not the fifth. The Gemara clarifies sources for these points. It's also said, based on a comparison of words in a verse, just like the guilt offering, the returning of funds cannot be done by night or in halves. Also, the returned funds must be sufficient that there's at least the worth of a pruta for every on-duty Kohen in the watch that he's delivering it to. Kohanim cannot exchange different restitutions by these laws to get different amounts. Additionally, these Kohanim receiving these stolen funds from a past convert, it's a debate if they have the legal status of heirs or gift recipients. There's a practical difference if leavened bread had been stolen, and Passover passed if they're repaid from the current or prior value. A different source does in fact reference this payment as a gift, which is what it is considered to be. The remaining points are qualified. It discusses this further regarding the order of payment and the bringing of the guilt offering between different watches, and that's the end of chapter 9. Chapter 10, the final chapter of Tractate Bava Kamma, brings some additional final laws of damage and monetary restitution. The first Mishnah says, if somebody steals an item and then feeds it or gives it to his kids and then passes, the children are not responsible to repay it. They would be responsible if the item was a legal guarantee for a loan. The Gemara says an opinion, if a thief steals something from a man, say some food, the man does not give up hope on retrieving the item, and then a second man grabs the item from the thief and eats it. The owner can collect reimbursement from whichever of them he wants, as he retained ownership through not giving up on the item. So our Mishnah, where the food was eaten by the children and they're exempt, must be where the owner gave up on the item. Based on the fact that we said, if the father left the stolen item with his children and passed, that they're exempt from repayment, this shows that the domain of an heir is the same as a purchaser. Others disagree and say the Mishnah's case is where they had consumed the item. The validity of this is debated further. A different source says if the father left stolen items for his heirs and passed, they're exempt from repaying it if they were children, and obligated to repay it if they are adults, but not if they say the father had repaid his debt to a different man. A different source says, so long as the items have not been consumed, whether they're adults or children, the heirs must return them. A different source says that they need to return the actual goods that were stolen, although some say this would not apply if they're children. This is debated further along with a related point on whether a court accepts witnesses in a case if a litigant is missing, depending on the unique circumstances. It's also a debate if a court can ratify a document without the litigant being present. It said we do, and if the litigant requests a delay to bring witnesses to prevent this, it's allowed. If he does not come, he's given the time of 3 court sessions, a Monday, Thursday, and Monday. And assuming he hasn't outright refused to come at this point, we then wait further, and he has a document which ostracizes him, written for 90 days, during which They do not go through his property in case he's in some stage of trying to get his finances together to repay the man. If he still hasn't come, a document of authorization is written allowing the other man to collect property as he desires from him. This 90-day delay also only applies if it's a loan. If it's a deposit, we write the document of authorization immediately. It clarifies what this document includes. Additionally, if the court sends an agent to bring a litigant to court, he has the legal status of 2 witnesses regarding excommunication, but not for documents of ostracism. Also, a litigant can be given a set court date to be passed by word of mouth. This would only apply outside of a city, as in a city people would assume he'd already heard and just not tell him. This all applies if he does not walk past a courthouse on his way home, as if he does, he would not be ostracized for failing to show up, as unofficial messengers would assume he'd been told of his court dates and just not inform him. Additionally, this would not apply if he comes home from a trip on a later date than when the unofficial summons was sent, as there's a possibility that they forgot to give it to him. If somebody refused to come to court and there's a document of ostracism written, it's only torn once he shows up to court. If somebody refused to listen to a court order, some say the document of ostracism is torn once he does as the court says, others say it's once he agrees to do as they say. The person has 3 tries to show up to court before the ostracism is written. 3 court dates, Monday, Thursday, Monday. This is said to apply to a man. A woman was typically always in the city, so they had 1 chance. It also clarifies other times that are not set as court dates around certain holidays, important dates, and otherwise. Back to inherited stolen items, we said if it's a guarantee for a loan, it must be returned. Some say it also must be returned if it's something like a donkey, as otherwise everybody would see it and speak poorly of the deceased father. Some say this includes a bed or a table. New Mishnah. Currency exchange and charity cannot be taken from customs or tax collectors, as they're presumed to be illegitimately taken. It can be taken from their person or at the market, just not from their collection chests. The Gemara says it would be permissible to accept change for less than a dinar here. Also, there's a general principle called dina de malchusa dina, the law of the country is the law, which states that whatever country or region Jewish people are in, they're obligated to follow the law of their country, so long as it doesn't directly forbid the practice of Judaism. So that there's concern of legitimacy towards tax collecting must be where the tax collector is allowed to collect without limit and abuses his power, or it's a self-appointed tax collector. In such a case, where there's an illegitimate tax collector, it's a debate if somebody is allowed to wear sha'anis, forbidden mixtures of wool and linen, to get out of paying taxes for such a garment, based on whether the fact that the intent was not to wear the clothes is taken into account. Similarly, before an illegitimate tax collector, as was mentioned in earlier tractates, it's allowed to take a false vow that your produce is teruma so that way he won't steal it. A different source seems to imply it refers to a non-Jewish tax collector, and some say you're allowed to get out of taxes with him. Others say that's forbidden, as it's a desecration of God's name. Related, it said stealing from a non-Jewish man is forbidden. Some clarify this to mean generally regarding theft and robbery, and others say that it would technically not be impermissible to abrogate a loan from a non-Jewish person, but it's still impermissible anyways due to the above issue of desecrating God's name. Further, it said theft and robbery from a non-Jewish man is outright impermissible, although regarding the principle of returning a lost object, some say the verse implies this specifically refers towards Jewish people, so it isn't an obligation towards non-Jewish people, although obviously it should still be done due to the concern of desecrating God's name. Additionally, it's legally permitted to benefit from a business error of a non-Jewish person, as seen in a few cited cases, although it's definitely preferable not to. Anyways, as mentioned, the established principle is dina de malchusa dina, the law of the country you live in is the law, and must be followed accordingly. It cites many sources for this. Further, it said if a Jewish man voluntarily testifies in a non-Jewish court against a Jewish man, he is excommunicated, as non-Jewish courts accept testimony from a single witness, which is viewed as illegitimate, which means if 2 Jewish witnesses testify in a non-Jewish court, there's no issue. Also, there is no concern with a single witness by a courthouse in a city, as this would make the defendant take an oath, which runs in accordance with Jewish law. It's unresolved if a single important person should testify in a non-Jewish court, as it's problematic as he's a single witness, as stated, but he's also important, so he can't exactly run away. Additionally, if a Jewish man sold a non-Jewish man property that bordered on a Jewish man's land, the seller would be excommunicated until he took responsibility for any potential damages, as back in those days it was a concern. New Mishnah. If somebody had his donkey confiscated by customs and then gives him a different donkey, or if bandits take somebody's garment and then give him a different one, he's allowed to use it even though it's not his, as there's a presumption the original owner gave up on the item. Also, if somebody salvaged items from a river, from soldiers, or from bandits, he can keep them for the same reason. Also, if somebody finds a swarm of bees, he can keep them, as presumably the owner gave up on them. A woman or a minor's testimony is believed if they testify where the bees came from. If the bees escape from somebody's property, he's allowed to enter another man's property to recollect them, and he must repay for anything he damages. If they settle on a branch, it's a debate if he's allowed to cut the branch to harvest his bees and later repay the owner. The Gemara says, a different source says the man would need to return his received donkey to its owner, as this opinion holds giving up hope does not make a person lose acquisition. Others say it means the person could return the donkey if he wants to. Regarding somebody giving up an object taken from a bandit, some say this only applies by a non-Jewish bandit, as a Jewish bandit would just be taken into a court. Others say it's the exact inverse, as a non-Jewish court will force a non-Jewish bandit to return what he stole, but a Jewish court would only verbally declare that he's required to, and not necessarily would he follow such a requirement. It discusses additionally how these principles would apply to laws of impurity. It debates if there's a difference between a thief and a robber by these laws. It also qualifies points on recovery of lost bee swarms. New Mishnah. If somebody recognizes some of his own vessels in somebody's possession, and additionally there's a rumor around that he had been stolen from, he's allowed to have the man take an oath as to how much he has spent on those vessels and give that amount to him. If such a rumor does not exist, he cannot do this, as it's possible that this man purchased them from the thief. The Gemara clarifies, the rumor must be legitimate, such as that people saw a man tunnel into his house and walk out carrying his vessels, and people are saying those specific items are his. These clarifications are said to be necessary if the owner sells his utensils. If he doesn't, a general rumor is sufficient to be allowed to reclaim his stolen items. If a thief stole an item and then sold it to another, the owner can only reclaim it from the second if he hadn't yet given up hope on the item. It brings further particular cases of restitution and reimbursement. New Mishnah. If somebody had a barrel of wine and another had a barrel of honey, which is worth more, and the barrel of honey broke, so the guy with the wine poured his out to save the honey, the wine owner can only collect payment for his labor, not for the actual wine, unless that was conditional on him pouring it out to save the honey. Similarly, if two donkeys were washed away by a river and one man saved the other's more expensive donkey, he can only be repaid for his effort, and not for the actual donkey, unless specified when he went to save it. The Gemara said similar cases to try and prove that the honey that's falling out is ownerless, but it shows how, in the respective cases, the barrels could have been saved, such as because they were additionally wrapped with a skin. This has relevancy in regards to the loss of tithes and impurity if such a barrel of produce breaks, whether it will cause its contents to become impure, depending on the situation. Related, it said that uncovered vessels containing liquids are typically prohibited due to concern of snakes going inside and causing the drink to become poisoned. If there's a vessel with a sieve above it, if the lower barrel is itself uncovered, it's still forbidden. But if only the upper vessel with the sieve is uncovered, the lower is fine, as snake venom would just float to the top. Additionally, the mouth of the barrel must be blocked in an additional manner so as to prevent the wine and venom from mixing. The discussion was about separating truma tithes, and it discussed impure produce, so it debates if this is permissible. According to this, it suggests it's dealing with demai, questionably tithed produce, and it's further discussed. To prevent these issues, if there is a barrel of impure truma wine, so that it's not accidentally given as a tithe, some suggest just pouring it out. Others say it can still be used to sprinkle around your house, and others say if it became impure in a house, it can be sprinkled. If it became impure in a field, it just needs to be dumped out. Others say aged wine can be sprinkled and new wine must be poured out. Regarding the Mishnah's case, where the man dumped out his wine to save the honey, and he made it conditional on him paying for the wine, it debates why this is apparently a legally binding stipulation. As we see in other cases, a person in an emergency, escaping from a prison for instance, offers a ferryman a large sum, a dinner, to take him across. He's not legally actually required to pay that, so it's explained he actually would if he caused the man a financial loss. For instance, if the guy ferrying him across was a fisherman and he's causing him to lose money, which is comparable here, where he's also causing the man to have a financial loss so as to save his honey. It also cites the additional case with the donkey, as in the wine case, the man directly poured out his goods himself. Here he's passively losing his donkey, as the river's just washing it away with him just choosing to save the other animal, so both are necessary. If the man offered to pay for the other's donkey and the second person saved his, as the case said, and the second man's own donkey washed ashore safe, the first man still needs to pay in full for the second man's donkey even though it's alive. It brings similar cases. If the second man fails to save the other's donkey, he only gets paid for his labor, and it debates this from other quoted situations. Related, if a caravan is attacked by bandits and they demand a particular sum, it's not taken equally from each person. It goes according to how much money each man has. If they hired a scout to take them through the desert, the scout is paid equally from each person. By donkey drivers who have set rates, they should go in accordance with that, and it brings examples. Similarly, if a ship is about to capsize and they need to throw the items aboard, items are tossed according to weight, not cost, and it should go according to the usual custom. Related, if boats are traveling together, they can stipulate to pay for anybody's boat that gets lost. This would not apply if the boat was lost through negligence, or if the boat sailed to a place typically not traveled. This would even apply if he sailed to his docking location from a different part of the year. It's also said, if a caravan is traveling and bandits steal their stuff, and one man saves everything and takes it back, he returns everything as it was. But if everybody else was unable to save it themselves, he has the right to keep it all for himself. Some define this case to apply specifically if the caravan members own the property in a partnership, meaning the guy who saves everything can either return it as it was, or he can dissolve the partnership and keep it. Others say this case refers to a guardian of the caravan saving the items, saying if he wants in that moment he can retract from his position, removing himself from his employer's jurisdiction, and claim all the items for himself. Others define this case to be where the other caravan members can also save the items themselves if they want, but it'll be really difficult, and the guy preemptively says he's going to try and claim everything for himself, meaning if they let him, they're apparently fine with that. New Mishnah. If a man steals a field and then bandits come along and seize the field from the thief, if the bandits are taking all of the fields in the region, the thief can just tell the owner, it's up to you to figure out. If they just claimed that particular field, the thief needs to get the owner a new field. The Gemara defines some of the wording in this Mishnah. Additionally, some say the case where these men are seizing all the fields in the region is where men demand to see this stolen field, and he shows him it and his other lands, and they seize all of the lands that he's showing, including this one. It brings a related incident. There are related points on whether a person can incur liability simultaneously, which it says does not apply, meaning if somebody pours another man's wine as an idolatrous libation, he's only liable for monetary reimbursement. It has a bunch of incidents regarding illegal seizures of property and the resulting situations. There are incidents, a time two men were fighting over a fishing net, and one of them just took it and gave it to an officer of the king, so it was ruled that he was excommunicated until he brought it back, and had a trial. Additionally, there was a time a man wanted to seize somebody else's straw, so he told the sage he was going to submit it to a non-Jewish court so that way they'd confiscate it. And the sage said he absolutely could not do that, and the man said he absolutely would do that. So another sage, Rav Kahana, stepped forward and broke the man's neck, and then had to flee the country. So he went to the school of Reish Lakish and was listening to a class by Rabban Yochanan, and he kept asking very difficult questions. So Rabban Yochanan lifted up his extremely long eyelashes to see this individual, and Rav Kahana had a split lip, so Rabban Yochanan thought he was smirking and he got offended, and Rav Kahana died. Later, Rabban Yochanan found out that's just what his face looked like, so he went to visit Rav Kahana's grave, but it was encircled by a serpent with its tail in its mouth, so he asked the snake to move, and it refused until he said he was the man's teacher, and then it let him pass. And then he prayed, and he raised Rav Kahana from the dead. Anyways, Rav Kahana then went back to the school after being assured he would not be dying again, and had all of his questions resolved. It brings a number of other particular cases of damage and monetary liability. New Mishnah. If a river floods a stolen field, the thief can just say it's the owner's loss. The Gemara says, this is actually debated based on interpretation of verses. New Mishnah. If somebody robbed, borrowed, or had an item deposited with him from somebody, he is not allowed to return the item to an unsettled area unless otherwise specified by the owner. The Gemara says, related, a loan can be claimed in any location, while a lost item or deposit can only be claimed in their location. Regarding returning an item to an unsettled area, if specified, this refers to where the depositor is depositing the item as he's going to an unsettled area, and the recipient says he's going there also, so he'll just return it there too. New Mishnah. If a man tells another, I robbed you, or you deposited something with me, but he's not sure if he returned the item, he needs to return the item. If he said, I'm not sure if I robbed you, or if I borrowed from you, or similar, he does not need to repay him. The Gemara says, a related incident, a man told another, I have 100 of your dinarim coins, and the other said, I'm not sure if that's true. It's a debate if he needs to pay it. Some say yes, as a certain claim overrides an uncertain one. Others say no, as the money would just stay with whoever currently has it. It tries to prove the other opinion from several sources. New Mishnah. If a thief stole a sheep and then returned it, and it died or was stolen, he needs to pay for it. If the owners were totally unaware of this entire sequence, counting and seeing no loss in their sheep, he's exempt from repayment. The Gemara gives a few explanations of this. First, if the owners know it was stolen, the thief must let them know when he returns it. But if they don't, he does not need to let them know. Others define this that whether or not the owners know it was stolen, the thief is exempt. Others say if they know it was stolen, he is exempt if he returns it without them knowing. And if they don't know, unlike the other cases, they don't even need to count the sheep to see it. It's the same amount for him to be exempt. Others say if they know the sheep was stolen, he's only exempt if they count and see none are missing, and if they don't know, he needs to let them know when he returns it. It debates between all these various opinions. New Mishnah. It's forbidden to purchase wool, milk, and kids from shepherds who tend others' flocks in case it's stolen. Similarly, it's forbidden to buy wood or produce from produce watchmen. It's permitted to purchase from women woolen goods in Judea, linen goods in Galilee, and calves in Sharon. If the seller tells the buyers to conceal the items, they're prohibited as they're probably stolen. Eggs and chickens are always allowed. The Gemara lists additional particularities of purchase, when some are permitted and others are not due to concerns of theft. This is further qualified. If there's a known robber, some say purchase from him is only allowed if majority of property is his. Others say it's fine if it's only a minority. If there's an informer who assists others in theft or misuse of property, it's a debate if it's permitted to destroy his own property. The debate is as it's allowed to harm his person, so perhaps this too. Others say no, as this also harms his children. These points are discussed, and it quotes many verses on the great negativity and punishment for theft. It qualified the listed goods from the Mishnah that are specifically allowed to be purchased. New Mishnah. Strands of wool found in garments by a launger belong to the launger. By a carder, somebody who prepares wool for garments, it belongs to the actual owner. A launger can take a maximum of 3 threads from the end of a garment. If it was a white garment, he can take any black threads. If a tailor left excess threads or a patch 3 finger breadths by 3, this belongs to the customer. Any wood shavings a carpenter removes with an adze, which is this, belongs to him. If it was removed with an axe, it belongs to the customer. If he was working in the customer's domain, everything, even sawdust, belongs to the customer. Gemara quotes a source which says, it's permitted to buy strands of wool from a launger by assuming they're his. Also, a launger can take 2 threads from the edge of a garment. This refers to thick cloth, while our Mishnah said 3 threads, which was referring to thin cloth. It's prohibited to card cloth, a particular sort of combing, essentially, along the warp by ordinary garments, but it's allowed by fancy capes, which look better if you do this. There are further qualified points and particularities on purchasing thread from a carder or from a dyer. Related, all excess threads on a garment count towards the minimum distance to the holes of its edges. Excess thread on a garment left by a tailor belong to a customer. It's explained this is a total of 2 needle lengths. It defines the different types of woodworkers' tools. Stone chiselers can take their excess stone chips. Regarding tree, vine, shrub trimmers, and similar, keeping excess leavings is dependent on the owner. Keeping daughter, or green grain, is location dependent if it's left to take. The city of Machashia is an instance of a place where it would be prohibited, as they're particular about these plants. And that's the end of chapter 10 and the entire Tractate Bava Kamma. Alright, that was a lot of information, so here's a rough summary of a lot of the practical takeaways from this tractate. There are various forms of property damage. It's very much case dependent, but broadly, if somebody damages a person's property, they need to repay them. If a person damages another person, there are 5 forms of compensation: payments for the damage, pain, medical expenses, loss of income, and embarrassment. And that's about everything. Thank you so much for watching.